Push to talk.
Push to talk to the.
Looks like we're rolling. You all set? All right. Good evening. Welcome to the August 11th regular meeting of the Scarborough Zoning Board of Appeals. The meeting will now come to order. This is a public proceeding. Okay, we'll go try with this now. This is a public proceeding, and unless the board specifically votes to go into executive session, the public has the right to hear everything that is being said and to view all of the exhibits that are presented. Please notify the chairperson, which is me, if you are unable to hear or see the proceedings. Please note that the virtual portion of our meeting is currently live, as you've all just saw demonstrated. You may find the instructions on how to join on the Town of Scarborough website. The board will work from a prepared agenda this evening that we will go over momentarily, but first, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. May we go through a roll call, please?
James Hebert.
Here.
David Bork.
Here.
Leroy Crockett.
Here.
Peter Freilinger.
Here.
Rudy Karen.
Here.
And Karen Shoup's absent.
Okay. Now, before we go any further, I'll note that our current agenda states that after the approval of the minutes, we will have a discussion related to the remote meeting policy, the approval of draft written decisions for the 4 appeals that were heard at the July 14th meeting, and then the 2 appeals that we're discussing this evening, the request for reconsiderations 2710 and 2711. I would like to I will entertain a motion to amend the agenda to remove items number 5 and number 6 to the end of the meeting. That is the discussion related to a remote meeting policy that pertains mostly to the zoning board members themselves. And item number 6, the approval of the draft written decisions. We can't necessarily approve the draft written decisions while we still have 2 of the applications that we're going to be discussing further this evening. So if someone would like to, Mr. Bork.
Yes, I make a motion to postpone items number 5 and 6 until the end of the meeting so that we can entertain the motions, the request to reconsider appeals number 2710 and 2711.
Excellent.
And I'll second.
Excellent. Thank you. All those in favor? Thank you. That's unanimous. And please note for the record tonight, Mr. Crockett is a full voting member. So that being said, we will have the discussion remain related to the remote meeting policy and the approval of the draft written decisions. We'll discuss that after appeals 2710 and 2711.
Mr. Chairman, point of order.
Yes.
Could I request that we have the discussion on the remote meeting policy after the discussion of the approval of the draft approval?
Sure. Yeah, we could do that.
Thank you.
Excellent. So let's go to the approval of the minutes from July 14th. Has everyone had a chance to review the meeting minutes from last month? Does anyone have any questions about the minutes that were entered or corrections, adjustments? Excellent. Do we have a motion to approve the minutes, Mr. Bork?
Yes, motion to approve the minutes of the July 14th, 2021 meeting.
Excellent.
I move second.
And then Mr. Karen seconds. All those in favor? That is a unanimous vote. Thank you. Okay, so what we're going to do now is go on to the request for reconsideration for appeal number 2710, the limited reduction of yard size residential appeal by Brenda Scally, 3 Lane by the Sea, Assessor's map U023 lot 88. Now, at this point, this discussion is just amongst the board of whether we will reopen this application for reconsideration. And for the board members, for our Our purview on this is we're not debating the merits or the content of the information that has been presented to us, only the understanding that the merits of not having due process provided last month is enough to reopen these for reconsideration. That being said, do I have a motion on the floor?
Yes,
Mr. Bork.
Mr. Chair, motion to reconsider Appeal 2710.
I motion to second.
Okay, all those in favor?
Roll call.
All right, that is unanimous. Thank you. That is a unanimous vote from all members. Was that appropriate, Mr. Longstaff?
You actually should do all roll call.
Let's do roll call votes from this forward. So Mr. Karen, how do you vote?
Yay.
I vote yay. Mr. Bork,
Yes.
Mr. Crockett,
Yes.
and Mr. Freilinger?
Yes.
Okay, so appeal number 2710 is now reopened for reconsideration. At this time, is the applicant or someone representing the applicant would like to come forward and speak on the additional merits and information that you've brought before us for reconsideration?
Thank you, Mr. Chairman, members of the board. My name is Paul Bolger. I'm an attorney with Jewel and Bolger. I represent the Scallies. They are the member owners of the applicant, the LLC that owns the property. First of all, I want to make sure it's understood. There have been comments that have been submitted that obscure or attempt to obscure the real issue, calling this a variance. This is not a variance. This is a limited reduction of yard size residential appeal by the owner of the property. The issues raised by commentators concerning ownership or residential use do not apply. Title 30 does not apply. The town standards, the ordinance of the town itself, are set forth in section 5, Board of Appeals issues that may be heard by the board, including the limited reduction side yard setback in this case. The request is for 9 feet. I concur with all the board comments and the comments of town council, which left only at issue number 1 and issue number 2 under the application and under the standard. So 1, the existing buildings or structures, were they erected prior to July 3rd, 1991? The tax card for this town of Scarborough did not indicate that there was a structure that existed prior to 2005 when the prior grandfathering was granted. And there was an expansion on the property. However, Sue Russo from the town has written to the property owner, and I apologize, I don't have multiple copies of this, but I'm happy to have a copy made and submit it for the record. But I will tell you what this says. Dear Brenda, the purpose of this email is to explain the reason the actual year built, or AYB, listed on the current property card for 3 Lane by the Sea is listed as 2005 rather than 1948, the age of the original cottage. For assessing purposes, the 2-story addition and breezeway permitted in 2005 contains 1,526 square feet of living area and offers kitchen, living room, 5 bedrooms, and 2 baths. For this reason, it is considered the primary living space. The original 1948 cottage is smaller and of 502 square feet of living area. I've attached a revised vision property card for fiscal year 2021 and 2022, and have identified the original cottage as section 2 of the property sketch. So that answers the question about when the original structure was built, and I think satisfies criteria number 1 of the ordinance under limited reduction of yard size. The second question was whether the requested reduction is reasonably necessary to permit the owner or occupant of the property to use and enjoy the property in essentially the same manner as other similar properties utilized in the zoning district. This applicant has submitted approximately 7 or 8 color photographs of various other properties in the area with stairways and decks similar to the one that's proposed for this property. So it is similar to properties utilized in that zoning district. In this case, and I guess I'd like Brenda to speak to this issue as well. It's my understanding that there is no interior access to the deck that is proposed, and therefore this exterior staircase at the back of the dwelling, which no one can see, is appropriate in this circumstance and necessary for the enjoyment of the property. Brenda has a disabled brother, and her disabled brother will not be able to access the second story of this property or the deck unless, given the other options, which were in one case ship stairs, and the other, I don't even know how they describe it, but I don't know, I can't, I wasn't able to find any similar circumstance of a ship stair in the neighborhood. There are ample examples of stairs and decks, but no ship stairs. Now, I'm not saying that there aren't some ship stairs somewhere, but they aren't appropriate for the access by Brenda's family, which is the critical issue for them. So this issue of use and enjoyment being essentially in the same manner as other similar properties. When we consider that other properties in the zone have just the same kind of stairs and decks as set forth in the applicant's package, the submittals, I think it's pretty clear that they are not asking for more than any other person has in the area where they're situated. Also that, and I want to emphasize this, this is not a hardship test. This is not a practical difficulties test. This is a very relaxed test in relative terms. And it is necessary to consider how people actually make use of their property as reflected in the ordinance, subsection 2. Town council and Mr. Longstaff had already indicated that there weren't comments on criteria 3, 4, and 5. I'm not going to address those, but I did want to clarify the record with respect to these, the number 1 and 2. And I'd like to submit a copy of the email from Sue Russo for the record.
Thank you.
With that, I would entertain questions by the board if there are any. Brenda, did you have any comments?
No, but the town attorney did mention that, that he believed that, you know, it met the cottage met the criteria for the pre-1991 erection. Which I believe you have a copy.
That's in the record.
Are there any questions from the board? Karen?
Just a, I do have a question. I am unsure of the proper method as we received additional information this evening as well as throughout the day. And the question I have relates to some of the additional information we had received. Is it appropriate to ask questions regarding that at this time?
I don't see why not.
Okay. Can I just ask for clarification with regard to the original intent and what was submitted to the town for the proposed renovations, the roof deck, and the access at the time, and he said sort of platform or deck outside.
What's that mean? Excuse me.
I don't know if that's something that can be brought up just to discuss. And where I'm going with that, as I mentioned, we did receive some additional information today. Photograph. All right, thank you for
Which
that.
was addressed by the town, and Brian is aware. It was built according to plan.
All right, so thank you for that explanation. And just to confirm, what is shown in the image that we received today, image 1670.
At the time, but it was built according to plan.
Probably best for mic technique, stand maybe on a foot or so back.
Okay. I can shout. Yeah. Did you have any more questions?
No, that was it. Thank you.
Okay, any other questions from the board? Okay. At this point, if there are no board questions, we'll go to any public comment. Is there a public comment? Anyone who wishes to speak? I guess first, I will open the floor for public comment. Would anybody wish to speak on this application at any point? Is that, are you folks coming up to speak? Excellent, thank you. Please state your name. Since there are a significant number of us here now, I'm going to ask that we all please keep your comments to 3 minutes, and I will be timing.
I'm here to accompany Mike Carey. My name is Jennifer Riggle. I live at 4 Lane by the Sea. I need to begin because I wasn't necessarily planning to come up here and speak tonight by sharing that I'm an attorney. I work for Bernstein Scher. Bernstein Scher is the firm that represents the town. I don't work on matters for the town. I'm not a municipal attorney. My remarks and any opinions I have are entirely my own personal opinions, not the opinions of the firm. I have not discussed this matter with counsel for the town or with any attorneys at Bernstein Scher who work on town matters. So I need to make that disclosure. I'm here as the owner of the property at 4 Lane by the Sea. I have a couple of comments to make, and this is not personal about the Scallies. It's actually really a question about process, and then I'm going to turn this over to Mr. Carey because he submitted some materials to the board, and we don't know if those have been reviewed and seen. The one comment that I want to make, although I have actually a number of questions, is the process where the abutters don't know anything about the new information that's been submitted, haven't seen the materials, and I'm hearing some of this information for the first time. And it seems that if there's going to be reconsideration, that the abutters who have expressed concerns should have an opportunity to address those. And I also want to mention that at the, I believe, second meeting, the board was told that it need only address 2 of the 5 criteria. And it seems to me where the board has been receiving additional evolving information about this, that the decisions made on other criteria where the abutters or at least one of the abutters has submitted an objection and questions, that the board then has an obligation to actually consider and evaluate all of the criteria. And it doesn't seem that that was done and should be done, especially since the board has now decided to open this up for reconsideration. That's all I have at this
Thank you.
time. Thank you very much.
Hi, my name is Michael Carey, 2 Lane by the Sea. With collaboration with other abutters, I've written several responses to the board, and I'm still not sure whether you've all had a chance to read it or absorb it.
We have, I mean, we have received all the information that was provided to us by the applicant in the town. We have reviewed it, with the exception of any information that was received within the last 24 hours. That information would be discussed here.
Well, I'm not sure whether I don't know whether I should read in my comments or what
You
you, I
certainly
don't know
may.
when you actually distributed the comments to the members of the board, if that was in the last 24 hours, but we sent it out more than 24 hours ago.
Then we would have had it, we would have had, because we receive our packets from the town at least 1 week ahead of time.
Yeah. Well, thank you. Like Jennifer, I'm not, this is some of the information that was brought forward this evening. I haven't seen. I understood that the initial building that I'm calling the cottage was built in 1948, and so way before 1991. But some of the structure that is being proposed to be built with this current appeal is going to be attached both to the 1991 structure, the pre-1991 structure and the post-1991 structure. And when that came up at the last appeal meeting, the board then voted 4-1 that that was not acceptable. And is this going to be re-litigated again this evening? Are you going to re-vote on that same issue?
Yes. Yes, we're going to be voting, well, we will be voting on this application again on whether or not it should pass or fail.
Okay. I didn't see from what the gentleman here said that it contravened anything that was already before you in the last meeting. Another thing that I want to bring up was of the pictures that Ms. Scally brought to demonstrate similar structures throughout the neighborhood. I haven't seen those, but it would have been helpful when she had done that if she had included the addresses. Then I'd be able to go out and see. I live right down there and I drove around all the Pine Point several times, looked at all the structures, and there are none anywhere in the whole area, such as the ones that she is proposing. I'm just saying that's information that really needs to be clarified at this point. Another thing that I noticed in the application was that the list of abutters was incomplete. I know that I was included, my neighbor on Lane by the Sea was included, and the other neighbor was included. But there's 3 other abutters on the north side, or maybe this is east side, whose names are not listed. So I'm wondering if everybody that should have had a chance to comment even knows that this is up for consideration. Another thing that I'd like to bring up, I have emailed this in before, but it was not, I got no conclusive answer. Was that on the, the roof deck itself, if you look at one of the plans, I think it's maybe S2 plan, the S2 plan. There's a comment that the height of the railings or the height of the deck should not be greater than that of the adjoining roof. But there are no dimensions in the plan to tell you what the height of the posts, the maximum height of the post could be, or it doesn't show you what the difference is between the height of the roof deck and the adjoining roof.
If I may interrupt, just with regard to building practice, that is regulated and guided by the town. So with a building permit that's issued for this and construction being done, inspectors from the town would go out on site to verify that it is constructed within ADA and current building code standards.
Are you I know there's an architect on the board here somewhere.
We have an architect and an engineer, and I will note that we are going over on time. So if you are able to wrap up your comments quickly, or.
Well, I'm just curious. It looks to me like if you were to build a safe railing around the roof deck, then the post would have to be higher than the adjoining roof, which would then disqualify the deck itself. And if we disqualify the deck itself, it makes the point of having a staircase moot. So I think it's something that would be good to clarify, because you didn't get the dimensions on the plan. So how would you know? And if you haven't been there to measure it.
I really appreciate the question. Again, with regard to building code, that is regulated by the town and the building inspectors and Mr. Longstaff's planning office, and not by the zoning board of appeals. We're here to discuss whether or not the applicant should be allowed to put a deck on their house. We're not actually designing the deck for them.
But you wouldn't allow the applicant to put a deck on their roof. It didn't meet these.
The zoning board wouldn't knowingly allow something to go forward that was an illegal construction. That again is regulated by the town through the planning office and the code enforcement office, the inspectors.
Great, I'm glad to hear it. If anybody has any questions for me, I'm ready.
Pardon me, Mr. Chair. I just want to emphasize or repeat something you mentioned a moment ago, that we, as the board, are unable to weigh in on any design. And it's more of a zoning issue discussion this evening.
Okay. Yes, Mr. Bork.
Just real quick, it's not a question, but a comment. It appears to me, seems to me that the roof deck was a variance for that, and the process of proving that was done by a prior board a few years ago. So subsequent to that, a building permit was issued, and I assume that construction started according to the information we've received. So this is all old information. It has nothing to do with what we're deciding tonight.
Well, yeah, that happened, but there have been there's been a number of stop orders and changes and.
Excuse me, Mr. Carey, if there are any.
Yeah, there was a stop order. No, there wasn't. There was a stop order posted on the building. If this gentleman says it wasn't, then I don't know.
Mr. Carey, actually, if there are, do we have other questions for Mr. Carey at this time? No worries. I think we're all set, Mr. Carey. Thank you for your time.
Yeah, thanks.
Is there anyone from the public that would like to speak?
I just have a couple of questions for Mr. Farnsworth. That's all right.
This is Mr. Longstaff.
Longstaff, I'm sorry, I keep getting your name wrong. The deck is already pre-approved, correct? It's already permitted. Access is permitted, whether it's a ladder or a shipsman ladder or whatever, that alternating staircase thing that can get approved. So the only thing really up for debate is safe access to the roof deck.
Yeah, the roof deck was approved. The access to the roof was shown on a plan but not dimensioned.
Right, and it got missed
When it
because of
was
COVID.
discovered that it did not meet the setbacks, that's when the applicant was made aware of that and given some options for getting that access. One of those options is why we're here, or why we've been here for the last 3 months.
Right.
Yeah.
And so really the only thing is what has everybody got wrong about safety? Putting in a safe staircase that doesn't affect anybody. Safe, sturdy, solid staircase. That's it. Mike keeps bringing up all this other crap that's irrelevant.
Thank you. Any other comments from the public? Would the applicant like to address any of those comments? You have this opportunity if you would like it. And at that point, if there are no further public comment, we'll move on.
I'll just comment very quickly. As has been pointed out already, the deck had been previously permitted and built. The roof deck, excuse me, aside from the roof deck, as far as applying, the applicant paid the town to identify abutters and notice abutters using the town's tool. And we have no knowledge or information about anybody not notifying abutters. The prior hearing, and thirdly, the prior hearings had addressed items 3 through 5 criteria in this particular, or with respect to this particular application. And it was noted by staff that the board already had substantial discussion on those issues, criteria 3 through 5, and did not appear to have any issues with them. So what's left are 1 and 2. Number 1 is satisfied by Sue Russo's comments and her amendment to the town's tax card. The last is whether or not this is a reasonable access similar to other access in the community. As to whether or not safety is to be taken into account, it's not in the ordinance, it's not in the criteria. It's whether it's reasonable. And my point was, it's different than a hardship. And that's all I have.
Thank you. I appreciate that.
Pardon me.
Yeah, go ahead,
Chair,
Bertie.
I just want to check if there was any additional written letters or information to be added.
There was a letter from Butter.
And while Mr. Longstaff's pulling that out, per to your earlier comment, ma'am, about discussions of the criteria 3 through 5. Last month, when we go through this information, the previous criteria that was approved with the subsequent information that was provided, it was determined that that had no bearing on the determinations for criteria 3 through 5. And I make it a point to check with the board members before we move on that if the board members are okay with their previous answers as previously noted in the record. And seeing that there were none, we moved on to the criteria that were undecided at that point, just to give a brief background. Additionally, for everybody in the room, items with regard to overall town process outside of this room is beyond the purview of the Zoning Board of Appeals. Whether or not building permits are or structures are constructed to code, again, that is with the Planning and Inspections Office with the town of Scarborough, not with this board. Our decision-making process here is strictly on whether or not this should be allowed to be constructed, not exactly where these stairs are going to go. It could go anywhere, but whether or not these could be constructed. Mr. Longstaff.
Sure, thank you, Mr. Chair.
Am I allowed to respond to that at all? I can be really quick.
Typically not, but if you would like one minor exception, if you would make this quick, please.
2 quick points. One is that the deck and the stairs should not be viewed separate because they are inherently connected. With respect to 3 and 5 and the board not revisiting that. At the first meeting, one of the statements that was decided by the board was with respect to whether there was any effect on the abutters. And the board said no, based on what was submitted. And my request or representation to you is that based on all of the information that has been submitted, including additional pictures and including submissions by abutters, that is something that I think is worth this board reevaluating, is because people can see that deck and it does impact potentially the neighbors. I won't elaborate, but that was.
Thank you. I appreciate that. And I'll also note previously that we aren't, no one has a right to their view as far as what other abutting neighbors decide to put up in their yard. Any further public comment? Seeing none, the public floor is closed. Yes, please.
You
Mr.
wanted me to
Longfellow.
read public comments. that we received?
Excuse me. Yes, please.
This, everybody else forgets about me until they need something.
Until we need you.
So we did receive another letter in addition to Mr. Carey's letter, which he went through the points on. We didn't receive that in time. I did forward it to the board. I don't know if all the board had a chance to review it, but I thank Mr. Carey for going through his points. We received this email, which was forwarded to the board. I believe you all did receive this, probably in enough time, since it was sent on August 6th. You probably had enough time to read it. It was from Alice Clifford at 101 East Grand Avenue. And just to summarize, she says she has absolutely no objection to the Scallies being allowed to finish the project, and indeed would urge the Board of Appeals to grant the variance to her. And she goes on for some length talking about a nice visit with the Scallies and so on and so forth. So that's the only other
Okay.
written comment that we've received.
Thank you, Brian. Okay, now that public comment is officially over, we can have a discussion within the small music break. We can discuss amongst ourselves the merits of the additional information and how that applies criteria. So I'll start with criteria number 1. Existing buildings or structures on the lot for which the limited reduction of yard size is requested were erected prior to July 3rd, 1991, or the lot is a vacant, non-conforming lot of record. Mr. Karen, would you like to start off?
Thank you, Mr. Chair. Is this, and just for my clarification, is this just for discussion or findings of facts?
Do both.
Yeah, this is findings of fact. Yep.
Okay.
Because we'll vote on this afterwards.
Following the previous 2 meetings, the information that was provided this evening through written documentation, the email, printouts, or testimony this evening, I think is in line with previous information that we may have received. But is appreciated, especially the photographic evidence. I had questions regarding if there were any modifications to the existing structure, that cottage that was dated prior to 1991. Information that was presented was that it was built to the same envelope, extended beyond, which was acceptable to the town. We also received information about the property cards. So I don't have anything more to add.
Okay, thank you. We can always come back as well. My note here as well, being confirmed by the town that the structure was built prior to 1991 and not in 2005, because I know that was a significant point of discussion that we had last time. But I'll start with Mr. Fralinger. Go this way.
Yeah, for folks who have seen this in the past, my concern on this has always been about this issue as to whether this would be considered a structure that had been constructed prior to 1991. I think the balance of evidence on this it falls on the fact that this structure is the cottage that was constructed in 1948, and we've updated the assessment record, and all that has been updated, or at least the information behind that record has been clarified. And the other thing I note too is that this stairway doesn't provide access to the other building, which I wasn't clear on the prior meetings. So this is clearly just to service a part of the structure that was constructed prior to 1948. And on that basis, I feel more comfortable as a result of the information we've received so far that this in fact would meet the requirements for item 1.
Mr. Crockett?
Yes, I would agree. I mean, if the town's amended it to say that it's within the guidelines and it is the one that we're looking at, then I have no problems with it. I didn't really have any problems with this one before. So.
Mr. Bork?
Just to comment, the original assessor's card was really irrelevant right from the beginning because it was not a legal document. And I'm glad to hear that the assessor has made the distinction that you know, the cottage is indeed, was indeed built in 1948, which confirms our attorney, our town attorney's position that this is definitely conforming to the prior to 1991 requirement.
Excellent, thank you. And the assessor's records confirm that the larger addition that was constructed was within the legal building envelope within side of the property line. So that note is to be noted as well. So we do an up-down vote, Mr. Longstaff, on this one? Yeah, I was the last one. So. Okay, so Mr. Karen, how do you vote on this?
Aye.
Okay, Mr. Fralinger,
Yes.
Mr. Crockett,
Yes.
Mr. Vork,
Yes.
and I will vote yes as well. Just due to the information that has been provided by the town. Number 2, the requested reduction is reasonably necessary to permit the owner or occupant of the property to use and enjoy the property in essentially the same manner as other similar properties are utilized in the zoning district. I'll start on this end. Mr. Fralinger?
Yes, I'm comfortable with this. I think some of the concerns that have been addressed prior is that there are other decks that have egress into the house. There are other decks that have only access from the house. To me, the point here is, does the applicant have the ability, or should they have the ability to enjoy a rooftop deck in this neighborhood? And based on the photographic evidence that we were provided at the last meeting, I think that it's quite clear that other houses in the area have that amenity. So I'm comfortable with this.
Mr. Crockett?
On this one, I would kind of disagree because I'm looking at the pictures again and I don't see any pictures of a rooftop deck with stairs going up to it. I see a deck that's off to the side of the house. That's not a rooftop deck with stairs going up to it, but all the other rooftop decks appear to be having access outside. I don't see anything that has outside access unless someone could tell me I'm incorrect on that.
Mr. Chair,
Yes. Ms.
I have up
Longstaff?
on the screen the very first photographs.
Oh,
That is a rooftop deck on a single-story portion of a structure.
That's considered.
That's a rooftop deck. I don't know how much clearer that could be. That's a rooftop deck with stairs on the side accessing the deck.
Because it's
And the
over.
address is given as 48 East Grand Avenue.
Because it's over a single-story portion of the structure.
All right, if you're clarifying that, then I'm fine with it.
Mr. Bork?
Yes, I'm also fine with this one too. And I'll point out that, you know, the specific language here says it's essentially in the same manner. So it doesn't have to be identical to what other properties are in the area. I believe one of the letters pointed out that the photograph here showed not only the stairs, but access from sliders, you know, from the inside the house on the second story. That's not the same, obviously. It doesn't have to be. It has to be, you know, reasonably close in order to afford reasonable use of the property, which this does meet.
Thank you. I'll acknowledge as well, my interpretation is per my other, based on the tax assessor's information when we were discussing this last month, question of what the primary building was constructed and which portion of the building that this deck was going to be attached to gave me hesitation on this particular piece of criteria last month. However, due to the information, again, shown by the town attorney that the structure is dated from 1948, it's the utilizing this in the same, roughly the same manner as other, and then you make an excellent point, Mr. Bork, essentially the same manner. It does not have to be exactly the same as every other deck in the area. I see no issue with this one as well. We'll start with a up-down vote. Mr. Freilinger,
Yes.
Mr. Crockett,
Yes.
Mr. Bork,
Yes.
Mr. Karen.
I just want to say I have no further comment. Yes.
Thank you. I apologize, Mr. Karen. Excuse me. And I will vote yes as well. The remaining three items 3 through 5 as, yes, Mr. Ward.
I would make a recommendation that just for the record that we just do an up and down vote on each of those remaining without any discussion beyond
going-
what we already have.
I was going to recommend the
make it
same
official.
thing, just so that's,
Mr. Chair,
yes.
could I also add that it would be appropriate to make sure that you ask the board members if anyone has seen any new evidence that changes their mind on any previous decision?
Thank
And
you.
if so, that should be entered into the record.
Thank you. So we look at criteria 3. Due to the physical features of the lot and or the location of the existing structures on the lot, it would not be practical to construct the proposed expansion, enlargement, or new structure in conformance with the currently applicable yard size requirements. Is there any information that was presented tonight that would change the board's vote, opinions, or findings of fact that have been presented tonight that would change it from the meetings 2 months ago? Okay, see no comment. We're going to up-down vote. Mr. Karen,
Aye.
Mr. Freilinger,
Yes.
Mr. Crockett,
Yes.
Mr. Bork,
Yes.
and I will vote yes as well. Number 4, the impacts and of the enlargement, expansion, or new building or structure on existing uses in the neighborhood will not be substantially different from or greater than the impacts and effects of the building or structure which conforms to the yard size requirement. Again, has there been anything presented tonight that would change your opinion on your answers that you entered 2 months ago for this criteria? Mr. Freilinger?
No.
No one else? No further comment here. Okay, we'll start with the vote. Mr. Freilinger,
Yes.
Mr. Crockett,
Yes.
Yes.
Mr. Karen?
Aye.
Now I'll vote aye as well. And number 5, the applicant does not commence construction of the enlargement, expansion, building, or structure for which the limited yard size is requested, so that the Board of Appeals is not considering an after-the-fact application. Now, this is obviously a little bit tricky, but was discussed and resolved previously because the building permit was issued before this variance was needed. However, the findings of fact and the conclusions that we came to in the previous meetings, if those still stand and no one has, I'll say, has anyone seen any information here tonight that would change your opinion or change your answers that you had previously entered on this criteria from any board member?
I think Mr. Karen addressed it, but answered.
Yep. Okay, seeing none, we're going to up-down vote. Mr. Karen,
Aye.
Mr. Bork,
Yes.
Mr. Crockett,
Yes.
Mr. Freilinger,
Yes.
and I will vote yes as well. Do I have a motion on the floor? Mr. Bork,
Motion to approve appeal number 2710 for a limited reduction in yard size for residential appeal by Brenda Scally at 3 Lane by the Sea.
so I have a second.
I second.
All those in favor? You see it. Thank you, Ms. Karen,
Aye.
Mr. Freilinger,
Aye.
Mr. Crockett,
Yes.
Mr. Bork,
Yes.
and I'll vote aye as well. Thank you very much. Next, we have appeal number 2711 for reconsideration. Again, not debating the merits of the content, only the due process the town wasn't able to provide last month. Is there any other discussion or points the board would like to make before we take a vote to reopen this for reconsideration? Seeing no comment, do I have a motion on the floor? Mr. Bork.
Yes, motion to reconsider appeal number 2711 for a special exception appeal by Emily and Scott Springer at 35 Honeywell Road.
I move to second.
Okay, all those in favor? Ms. Fryer,
Aye.
up and down, yeah. Mr. Fralinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes,
Mr. Karen?
Aye.
And I'll vote aye as well. Is a representative of the applicant or the applicants like to come up and speak and give us an update on the information provided?
Good evening, members of the board. My name is Gerald Schofield. I'm here on behalf of the Springers as part of their appeal. Thank you again for taking the time for allowing us to be before you. We greatly appreciate your attention. We are asking this board to reconsider its July 14th denial of the applicant's application for a special exception for commercial agriculture. It's my understanding that based upon the past meeting and the past votes, that this board has determined that the applicant has met the performance standards for commercial agriculture in sections A, B, C, D, F, G, H, and I of the standards for special exception. By a 3-2 vote, the board determined that the applicant failed to meet standard E at the last meeting, which is the standard for special exception. That standard reads as follows. The proposed use will be compatible with existing uses in the neighborhood with respect to physical size, visual impact, intensity of use, proximity to other structures, and density of development. We respectfully request that the board reconsider that decision and vote to conclude that the applicant's application does in fact satisfy standard E based upon the additional information which was submitted with our application, as well as the comment that you'll hear in this evening tonight. First of all, standard E is vague and it's not sufficiently quantifiable standard for the applicant to be able to satisfy the board's requirements. Ordinances that establish a criteria for acceptance of conditional use must specify sufficient reasons why that use may be denied. Failure to do so creates an impermissible delegation of legislative authority because standard E is unmeasurable with no cognizable quantitative standards set forth to the applicant. Absent specific standards creates a denial of equal protection of the laws to the owner who is rendered to a state of uncertainty with respect to how to meet those laws. And that's supported under Maine's case law in Wakeland v. Town of Yarmouth and Waterville Hotel Court v. the Board of Zoning Appeals. A lack of such standard permits a board to exceed its quasi-judicial function as it allows boards to roam into policymaking, which law and the Constitution does not permit. Boards' decisions would vary regularly if such were the case. It opens the door for favoritism and discrimination by permitting a board to grant or deny special exceptions for reasons unconnected to the ordinance that masquerade as quasi-judicial findings of fact. That's also found in Wakeland v. Town of Yarmouth. There is no quantifiable standards for section E. And when I say what that means that there is no standard for what constitutes physical size, what constitutes a definition of visual impact, what quantifies as intensity of use, or for that matter, what constitutes proximity to others, particularly where the proposed use meets the existing setback requirements. Nowhere is there any guidance to the applicant. Rather, the Zoning Board of Appeals is free to express a legislative type opinion on what is appropriate and what the court in Kosalka v. Georgetown expressly stated was not permitted. The board has previously stated that the proposed use isn't compatible because there isn't such another use within the Honeywell neighborhood. There's no other commercial farm. If such is the case, then the standard for special exception is not a standard at all. It's an outright prohibition, and it renders the special exception meaningless. This is the reason why special exception uses exist. Commercial uses in the R2 district are not permitted. They are permitted as a special exception, and it doesn't change the district from R2 to commercial. It remains a permitted use within a residential zone. If the board's decision here stands, the practical effect is that a new business could never be approved if one had not have previously been approved before. You would never have a business of first impression. Such cannot possibly be the intent of this town's ordinance, and such cannot be met by the standards of E, which are unquantifiable for this applicant to be able to meet that standard. If you look further to the town of Wakeland v. the town of Yarmouth found at 523, 828 second, 575, which was all submitted to this board. The Yarmouth Zoning Board of Appeals denied the applicant's request for special exemption to renovate a house and barn and create 3 rental apartments. The town denied the application based upon the exact criteria in Yarmouth's ordinance as standard E in this town's ordinance, the exact same language of standard E. The court ruled for the applicant, finding that the controlling provision of the ordinance was devoid of the constitutionally required specific standards necessary to guide the board in deciding upon the application for special exception. The court ordered that not only that the ZBA grant the application for special exemption, but the Supreme Judicial Court of Maine upheld that decision and found in favor of the applicant, and the use was approved without further condition. That's the exact scenario before this board tonight. I would respectfully submit to you. We have an application which has been denied based upon standard E, and the quantifiable standards for meeting that exception simply don't exist here. Second, there's been neighbors and perhaps one board member who have suggested that property values would be lowered, and they stated that as conclusive matters of fact. While it may be true that property members can speculate as to their own opinion as to what effect it might have on their property values, it's my understanding from reviewing the entire record that not one person who's made any statement is a realtor, and nor do they have any statement as experience as realtors. We've submitted written evidence from 2 realtors, one of them being a direct abutter, who have stated that in their professional opinions, the effect on property values will not be diminished. And what I think is particularly important for this board to consider is that the proposed use is a lawful use. The Springers could farm more of their land if they wanted to. It's solely an online presence of selling things online, excuse me, that makes this even necessary to be here today. Assuming this board would deny this application, they could go home and they could farm it harder than they've ever farmed it before. And the neighbors would have nothing to be able to say about it. They simply couldn't advertise online, which is invisible to the eye from any abutter. And as one of this board members astutely said before, no neighbor is entitled to a view. And the Springers property is almost invisible from everywhere, except for a few spots on Meeting House Road where you can see their vegetable gardens. Third, it's our position that the board looked outside of the application in its denial. The board needed to review the proposed use applied for without imputing facts that were not contained within the application itself. The board, pursuant to the ordinance, was to conduct a de novo review of the revised application, which was expressly permitted by the board, which we greatly appreciate. And it needed to review the facts for the application that was actually applied for. Rather, it was asserted on a numerous basis that the proposed use would be denied because there was concern of its scaling or morphing into something that it wasn't otherwise applied for. If such were the case, the applicant would need to be permitted for that, and they would have to come back to this board to apply for a new permit for such additional use. But that's not what they're applying for here today. They're applying for that which was set forth in their application, which was heard on July 14th, and nothing more. And it's our opinion that it's impermissible to consider outside factors, such as the fact that there was a bus accident on Honeywell Road, and denying them an application based upon standard E. There are accidents everywhere, Honeywell Road included, and the fact that there was one bus accident should not have been considered by this board as a negative factor in favor of disapproving their application. Lastly, whether or not the town can or will enforce the granting of the proposed use and any conditions applied to that proposed use by this board was also held against the applicant in denial. The town's ability to uphold and enforce its own ordinances and permits because of COVID restrictions or lack of enforcement shouldn't really be weighed against an applicant that's before this board today. Rather, the only thing that should be considered is the actual application before the board, what the proposed use they're applying for is, and whether they can meet that standard. And in light of the additional evidence for standard E, I respectfully suggest to this board that the applicants do in fact meet standard E. Based upon all the facts and circumstances, and because the ordinance provision upon which this applicant was denied will not survive judicial challenge, We respectfully ask that this board reconsider its vote on standard E and approve the applicant's revised application. With that, I'm going to allow the Springers to make a statement.
Thank you.
Thank you very much for your time. I appreciate it very much.
Very welcome.
Good evening. Thank you so much for giving us your time again, one more time this evening. I really appreciate it. I did want to take just a couple of moments and clarify a few things that were perhaps misunderstood at our last meeting. I want to tell you, I have a very, very small business. In fact, the legal fees for this adventure we've been on will far outweigh anything I will bring in this year. We base that business on what we grow and then selling the extra vegetables, selling the extra flowers, and what we're growing for our family is primary, and what we're selling is extra. We consume over 50% of what we grow today. I also wanted to explain a little bit about the business because there was some confusion last time. We have one business. When I blend tea, it's infusion herb from the apothecary. When I'm selling just a plant, it's Meeting House Farm. I know that sounds big. It's not. It's just the way that I put it together to market. The other piece of information that was perhaps confusing last time is that I also represent 13 other farms in the state of Maine. This is true. I am a salesperson for them. I do their marketing and I do online work for them. At no point do we process plants for those farms. I'm not a processor for those farms. I'm a marketer, a salesperson, no different than someone who sells Avon or Roden and Fields or any other salesperson. I used to work in insurance, and sometimes I had pamphlets for clients and I would take them out and sell them to that client. This is no different. It is not an item to be considered around scale because that is a completely separate piece of the business that is entirely online. So I really wanted to make that clear tonight before the board. Finally, one other point of clarification. We have less than one FTE working to pick flowers during the summer. I asked for up to 5, but we would never have more than the equivalent of one FTE working to pick. So we're really small. Oh, full-time employee, excuse me. I did spend 20 years in the corporate world, so that slipped out. Full-time employee. So in other words, it's very small. I'm just trying to give you an idea of scale and let you know, we might have 2 people picking, but overall, it's not more than the equivalent of one full-time employee. So I just wanted to make that clear. All right, thank you very much. Thank you for your time. Thank you for hearing us again.
Do we have any questions? Thank you very much for clarification statements. Do we have any questions from the board at this time? Mr. Frelinger, I'll let you start.
Question for the, excuse me, probably need a cough drop, but other than that, for Mr. Watson, or the attorney, please. What you kind of implied on the decision in Yarmouth would effectively neuter section or item E of any relevance and consideration. Do you think that there is a room for this board to incorporate the questions of the proposed size being compatible with existing uses in the neighborhood et al? Or do you think that item E effectively is largely unconstitutional and unadjudicable?
Well, first off, I must state that I can't give the board's advice because I'm not the town's attorney. It would be my representation and my opinion on behalf of my clients that to the extent that this board were to deny their application based upon standard E, that they would have a very good chance of having a court overturn that decision and say your application is going to be granted because there are no quantifiable standards. And I don't think that the board can sit here today in your capacities as board members, nor would I think any one of you would want to assume that liability of trying to define what those quantifiable standards are of standard E for the first instance. I don't think that would be good practice for anybody. So I think that's how I interpret it.
Thank you. Also point out just for the board's benefit too, that we don't take case law or anything that has any kind of precedent into account for our decision-making process. Everything has to be what has been presented before us in letters, information, and items that are put inside the application. That is what we have to take into account. Though we do respect and understand the importance of case law. That's not what we're not a judicial body here, and that's not what the role of the ZBA is. I have a question. You had stated last month that you're willing to accept a number of restrictions should we allow this to pass. And those would possibly include not allowing more than 5 vehicles in the driveway. That would be between the hours of 8 and 5 p.m., 8 a.m., 5 p.m., Monday through Friday. No vehicles parked on the street, no drive-up sales, everything would be online. There would be no exchange of product to clients at the property itself. It would all be hosted off-site, not at 35 Honeywell. Are those kinds of restrictions you folks would be amenable to at this point?
Yes, they are, Mr. Chairman. I think Billy stated that at the last meeting, and
Yep.
we are willing to state that again here today.
Okay, thank you.
In fact, there's Attorney Jones, who's here this evening, submitted a letter to this board on July 14th. And it contained a list of, I believe it was 12 or 13. Hold on one moment, please.
Yes, there were a number of them.
Yes, there were 12 criteria that the Donahues would like to see if this board were so inclined to approve the application. The Springers are willing to accept every last one of them, save for number 11, which was a requirement for a 50-foot side and rear setback. That one really can't happen, but the current Springers currently meet the setback requirements. They will keep the green barrier that currently exists, in which this board has seen in visual depiction through the pictures that were submitted. MOFCA, which certifies the farm, requires a 20-foot setback in any event. Otherwise, they wouldn't be able to keep their certifications. So they would be more than happy to submit to all of their requirements, save for the 50-foot setback, and they would ask that it simply comply with the town's setback, which is already set forth in its ordinance.
I'll follow that up with one additional question / comment. Given the amount of, I'll say, concern that some abutters have raised with respect to your business, should the board approve this application going forward, I think it would be very important to try to work with them as best as you can, knowing that, this is a really hot button item for a lot of folks that are here right now, whether or not the board votes yes or no on this application. And I guess this is more of a comment than a question, so I apologize, but I think that's just a general item to keep in mind, that we are all still neighbors here. Any questions from the board? Yes, Mr. Frelinger.
For Ms. Spring, I appreciate actually giving the additional detail on the processing or the lack thereof, or what it is. That actually is kind of new information to me. I had understood in the prior meetings that you were in fact getting product from other farmers and doing some blending or making teas on their behalf or making lotions. Could you just clarify that for us?
Sure. So I do make tea from what we grow on our property. Occasionally, I will order something online like cloves to add into it, but I am not processing for other farms. They're called value add products. The value add products, which would be my blending a tea or my taking flowers and putting it in oil to infuse it, is all done in the kitchen. So this is not an industrial operation by any means. And I have a home processor's license, which means that I'm doing it in my kitchen. So we're not talking scale here. And I'm doing it for what we grow on our farm. I act as a marketer and salesperson, creating a website for other farmers, because farmers do not like to market and sell. So I'm helping them out there.
No, I appreciate it. Like I said, that it was not clear in the prior meetings, the scale of the processing, quote unquote. And I just wanted to get some clarification for that.
You can imagine me in my kitchen blending tea in a bowl.
Understood.
Okay.
Any further questions from the board? Okay, thank you. Thank you very much.
Thank you very much,
Appreciate it.
Mr. Chairman.
At this time, we're going to open the floor for public comment. There are a significant number of you tonight, so I will be strict with the 3 minutes. I'll sort of give you a warning when you're approaching a 3-minute mark. I don't want to have to gavel anyone tonight, but I will. So if anyone would like to please speak, please come to the podium, state your name and your address and what you would like to say.
Good evening, thank you. My name's Heidi Seeley. I live at 3 Elysian Way, which actually is, I believe, a direct abutter behind the property in question, if not just a kitty corner abutter. I've lived in Scarborough for about 5 years. The piece of property that I live on was actually an 11-acre parcel that got broken up into 3 pieces. So I have a pretty large piece of property similar to the farm in question. I just wanted to give my support for this farm. I love walking by it. It's beautiful. It's well maintained. I think it adds a lot to our neighborhood. And I want to give support to the enterprising spirit. I think it's important as members of this community that we want to encourage small businesses. I think it's great that she's doing what she's doing. And it's disappointing to see that some of my neighbors are so opposed to this. So I encourage you guys to allow this to proceed and support the business in question.
Thank you.
Good evening. Greg Stragowski, 19 Sequoia Lane, right around the corner from the Springers. So I'm honored that they asked me to be character witnesses for them. I've known them for 20 years. They are high integrity people. They're very giving to the community. And the biggest thing I can give on their behalf is I've started 2 charities, both for kids. One for kids with cancer, one for at-risk kids that raised hundreds of thousands of dollars for kids who couldn't do for themselves or kids that were dying for the Barbara Bush Foundation. And every time I asked the Springers to be there for us and for the organizations, they were good neighbors, as the chairman said. They are responsible, great humility, as you see. They take the high road. And I know some of the neighbors have not, but I always expect that from Scott and Emily. Good neighbors. I mean, I live next to them. I stop by all the time. I'm proud to call them my friends of 20 years, and I hope they succeed in this endeavor. Thank you very much.
Thank you very much.
Hi, good evening. My name is Sherry Parks. I live at 5 Lillian Way, so I'm not in the neighborhood, but I am honored as well to be a character witness, specifically for Emily Springer. I don't know Scott as well, but I worked with Emily in the corporate world for many, many years. Found her to be highly responsive, just a great partner. And when I started a program supporting women, she was the biggest cheerleader. And let me tell you just a little bit about this woman. Hard worker, a go-getter, somebody that's an entrepreneur. And she was very, very, very successful in the corporate world. But she wanted to follow her passion. She wanted to make plants and then make tea out of plants and make herbal remedies to help people heal. And don't we, in a world that is quite a mess at the moment, need people like that? That is the heart of Emily Springer. And that's what she's all about. She's not trying to make $1 million. She's not trying to scale. She's literally trying to use her passion of medicinal plants to heal people. So I really hope you reconsider, and I really hope you approve this, and I really hope her small community embraces her and what she's trying to do. Thank you.
Thank you very much.
Hi, my name is Allison Nealand. I live at 19 Jamico Mill. Sorry, I'll hide behind the podium. I live at 19 Jamico Mill Road in the neighborhood of Meeting House. I live there with my husband and 3 young children and a crazy energetic dog who needs frequent walks. And so we find ourselves walking by Meeting House Farm at least twice a day. My children are on their bikes and rollerblades frequently around the neighborhood independently. I'm grateful that we have really nice sidewalks through the neighborhood and neighbors who are so courteous and always watching out for the children. In all our frequent walks going around the neighborhood, I have never seen any traffic concerns at all. So I was shocked when I heard that some neighbors were concerned about this because I feel like I'm very present in the area. But more important even than that, although safety is of course a concern of mine with my children, I also just want to share with you how Meeting House Farm fits into the character of our neighborhood so beautifully. And that farm was the original farm of the area. So the building itself has historic significance to our neighborhood, and it's something I've shared with my children a lot. And as we pass the farm, the only part we can really see is the vegetable garden along the side near the sidewalk. And my children always pause to peer in at the vegetables being grown and the fruit trees there. And that has particularly inspired my 6-year-old who came home this summer insisting that we start our own vegetable garden. It opened up conversations of sustainability and how food is growing and about the importance of biodiversity when so many of our lawns are just grass sprayed with pesticides, that instead growing some of our own food in our own yard maybe can help solve some world problems. I mean, the topics got big and important. It also led to this conversation where my 6-year-old, his best friend in the neighborhood is now our elderly neighbor who is a bit homebound because of COVID. But because of vegetable gardening, they started this conversation out in the yard one day, and they see each other every single day and talk about growing cucumbers. And I honestly give credit to Meeting House Farm for fostering that community connection because my 6-year-old saw the vegetables there. So this is incredibly important and certainly not unique in our neighborhood. Just a couple blocks down, we drive by a small stand that a neighbor has put up that is selling flowers out of that stand. A couple blocks in another direction, we can go pick blueberries in a neighbor's yard. It absolutely fits the character of the neighborhood. And I certainly hope those people with blueberries and flowers won't be scrutinized through a zoning process. But I'm here to offer my full support for Meeting House Farm.
Thank you very much.
Hi there, my name is Margaret Logan and I live at 4 Overlook Drive and I am an abutter of 35 Honeywell Road. And I just want to appreciate and thank my fellow neighbors who have come out tonight to celebrate the Springers. They are truly incredible people. I want to support also the entrepreneurial spirit that I think is very true to the state of Maine. I have a special perspective. I actually grew up at 35 Honeywell Road. My parents bought 35 Honeywell Road over 40 years ago from the Caprons, I think. And we had it in our family for just about 40 years. My folks have both passed now. My father, Theodore, was a founder of SEDCO and also was at one point chair of the planning board here in Scarborough. And he was a firm believer in the entrepreneurial spirit and doing for oneself and allowing people to succeed and sort of do as they see fit, but give back to the community and support your neighbor and create communities of strength and of service and of pride. It's a beautiful home. The Springers have done an amazing job bringing it back to life. It was a rental property for many years. And I know my family, I'm the only one here, but I'm the youngest of 8 kids. We all support the Springers. We all support their endeavor to create this small farm. We think it's very true to the spirit of the property, of the home, and of the essence of the community in which we live. And so I just want to throw my support along with everybody else's to the Springers. They're great people. They're doing wonderful things. And it's a truly beautiful homestead that enhances the community and the property. And again, I'm an abutter and I am thrilled. I think it's enhanced property values. And I know it's a standout of the neighborhood. So I firmly endorse and support the Springers. Thank you.
Thank you.
Good evening. My name's Joellen McGovern and I live at 31 Jamico Mill Road. I've lived there since 2003. Prior to that, I lived in the Dunstan area since 1987. Although I wasn't born a Scarborough resident, I've been one most of my life. My husband Terrence and I determined early on we wanted to raise our family in Scarborough because of the family community, the quaintness of it, and for safety. We educated our 3 children here, and because it's a family community, the quaintness of it, and for its safety. Excuse me. When I moved to Scarborough from Portland, it was clear that we moved in during an evolution of growth that was happening, and Scarborough was not accustomed to it. There was a drive to keep farmland, while many locals made us aware that Scarborough was made of farmland. The locals did not want to lose that. I was actually told that my home was built on their blueberry patch. Local people told me in my current home, that's in the neighborhood that the Springers are in, that my home was built on their hiking paths and berry patches. It means the world to people. My walking path takes me by Meeting House Farm frequently. It's always neat, kept, and quaint, just like our neighborhood. We are a community that cares for children, parents, and seniors. People are constantly walking their children, their pets, and whole families by my home and around our extended neighborhood. The environment does invite farm fresh opportunities and allow our families to learn more about our food sources and herbs. In fact, it's perfect. Meeting House Farm is small and quaint from the street view. It fits. A stand fits. If it doesn't, then neither does the flower stand on Elmwood Avenue. Neither do the lemonade stands that kids put up to sell their drinks, or even the small giving libraries that are all around. That, of course, sounds ridiculous, which frankly, it's ridiculous to indicate that Meeting House Farm can't sell their produce or flowers. I stand with Meeting House Farm in their plan. It helps bring us back to a time that farms were very important to Scarborough and allows us as neighbors to get farm fresh goodness and education in a healthier lifestyle. I stand by Emily Springer as a person with a track record of a planner, a communicator, and only trying to make her community better. Please allow for our neighborhood to continue our quaint way of living while getting some nourishment along the way. Thank you for your time and consideration.
Thank you. Anyone else?
Good evening and thank you. My name is Darlene Greenfield and I live on Maple Avenue in Scarborough, just kind of down around the corner from Meeting House Farm. And there's really not a whole lot I can add because everybody has said just about everything that I wanted to say. I've lived on Maple Avenue for over 50 years. I've seen all the changes on Maple Avenue and it just always makes my heart feel good and I'm a walker. So I walk by and up around the neighborhood many times a day with my dogs or by myself because I love to walk and I love what the Springers are doing to their home. They are such great stewards of their property and their home. And it has changed so much over the years after, like I said, I've been there 50 years. So I've seen a lot of changes and I love what they're doing. And I just don't understand how anyone can say anything negative. I would love to see a little farm stand there and they can sell some of their overages because I would be there. And I've never seen a whole lot of traffic. The only traffic I really see are the trucks that are there to do the neighbors' lawns because all of the new neighbors want their lawns done. But other than that, I don't see a lot of traffic there. And and I only know the Springers just from my walks in the neighborhood when I praise them for all the hard work that they've done and to keep the neighborhood looking beautiful. Thank you.
Thank you very much. Is there anyone else?
Good evening, Jennifer Cleary, 33 Meeting House Road. I just would like to remind this committee that back in November, when this original appeal was brought before you, that the scale was completely different than it looks today. There was a lot more, it looked like a much bigger project, a much bigger farm as far as what they wanted to get out of it, what they hoped to build, farm stand, retail store, selling herbs, oils, teas. That has totally scaled back, which I appreciate. I do have a lot of concern over the traffic. Honeywell Hill is one of the fewest in the entire neighborhood that does not have a sidewalk. I think it's like the only one. So I just wanted to remind you of the scale that this originally started at and where we are today. Because the town has, Jay Chase in the last meeting fully admitted that there is no way for the town to monitor what is happening if you put any constraints on this appeal. So the other thing, comparable use was the reason why this was not approved at the last meeting. Nothing has changed since then. 4 out of 6 voted against that last meeting. I'm including Mr. Crockett as an alternate. So I just wanted to remind you of that. I can't see that anything has changed as far as comparable use between now and a month ago. I also want to mention that, you know, not only was this original farm sold for profit and subdivided and houses were built and an R2 district was built, it's very large. Layton Farms, which is now attached to this area, is in phase 4. I mean, in no time at all. Scarborough is growing drastically fast. And we have had, as a town, a lot of infrastructure conversations to ensure that we're ready for this growth. That area now has more than 50 homes. So that is in direct comparability to our area. And one thing that I want to say, you know, things like this can open a can of worms. There are other people in the district that have large gardens. What if they all come to you and say, well, I would like to start selling? Where does that go? And I will use an example. I don't know these people, but there is a home on Maple Ave that has very, very large gardens in their backyard. And they, you know, what do you say to them if they come and ask for the same exception? Thank you for your time.
Thank you very much. Anyone else?
Hello, I'm Mary Floyd. I live at 32 Honeywell Road since 1976. So I loved seeing the Logan house, yes, become a vegetable garden and an herb garden. They put up a fence, they have a circular driveway and they put up a fence and no car is ever on the street. There's always in their driveway, a couple of cars. Most of the cars are coming down from the development that was built. And when people picking up their children are parked on Meeting Hill, you can't get down because the people that live down there are picking up their children from the school bus. So as far as traffic goes, it's not from the farm. It's just from the houses that are built. And I don't understand why it was never accepted, because it was very quaint and quiet and nice to look at when you walked around. And I see a lot of my neighbors that walk by my house. So we all love it. We all love it. Thank you.
Thank you very much. Anyone else?
Hey, everybody. Hi again. David Cleary, 33 Meeting House Road. My wife made most of the comments that I would make, but I'll just say R2. It's R2. It's an R2 zone. I walk by the Floyd's house every day. I walk 7 days a week. I walk by J. McCo, 31, 7 days a week. Love to walk my neighborhood. This isn't about loving to walk the neighborhood. This isn't about loving the character of the farm or thinking the gardens look nice or don't look nice or look mangy or look overgrown. This has nothing to do with that. This has nothing to do with the fact that your family sold it for profit and it's an R2 zone and it was redistricted. It's residential. And it doesn't really matter this is about, that this is an R2 district, and this board is being asked to make an exception to an existing zone. It is not your obligation to make an exception to an existing zone. That's not for this board to consider, and that's not a matter of this discussion. The other thing that I would like to just state is Mr. Schofield brought up a whole minefield of legal vomit with a veiled threat of litigation against either this board individually or the town. And I would say that that's not for this board to determine. If the state of Maine were to overrule, so on and so forth, you have in front of you item E, compatible use. And a month ago, Mr. Freilinger, Mr. Crockett, Mr. Hebert, and Ms. Shoup, 4-2, though technically 3-2, because Mr. Crockett at that time was an alternate, voted against this for compatible use. And nothing has changed in a month, other than rising a bunch of people here. That's all that's changed. Thank you.
Thank you. And one quick moment before we go any further. Just one step. Public members to speak. It's up to you. Okay. Just one quick note. This use is permitted in the R2 zone, but they have to come before us for this application. So it is not a rezoning or redistricting of the zone. Just sort of a point of fact. Ma'am, yes?
Hi.
Excuse me?
Are they allowed to speak more than once?
It's at to the determination of the chair, which is me, and I've already allowed it tonight. And as long as everybody keeps it cordial and polite and to 3 minutes or less, I will allow it. So, ma'am, you may go.
Hi. Well, again, I'm Margaret Logan and I grew up at 35 Honeywell Road. And I just wanted to speak to the Clearys. I'm not sure what you meant about selling it for profit, but I do know that you bought a house on the subdivision. So you're enjoying your time on the property.
Excuse me. This is not applicable to this discussion at all.
Right.
About
Sorry, I just, again, wanted to really genuinely support the Springers and speak to the essence of the neighborhood. And the neighborhood wants to support this. We believe in what the Springers are doing. They are adding value. They are enhancing the community. And I'm not sure what this is very contentious, but I do want to say this. I'm not sure what the Clearys are bringing to the community. I mean, that's a fighting spirit. And I don't feel that you're supporting.
Ma'am, hey, folks.
And there's another business on Honeywell Road outside of the
No,
hospice.
ma'am, I'm sorry, please.
Just if we're gonna talk about it, we should talk about it in its entirety so that it's fair.
I will
to the
close, please, we're keeping this cordial and civil. If this continues this way, I will close the public hearing and we will move on from there. Ma'am.
Good evening. My name is Shay Watson and I'm an attorney representing Mark and Pamela Bernstein who live at 39 Honeywell Road, right? They're the next door abutters. And I want to begin this by prefacing that this is not about the Springers character, and it should not be about the Springers character. And I know you all may recall, we submitted a letter last month on behalf of the Bernsteins. And prior to that, back in June, we submitted another letter. In the June letter, the Bernsteins explained that they had a lot of concerns and there were a lot of issues that they believed needed to be addressed by the Springers in order to make this something that would be compatible with the neighborhood. They had discussions with the Springers and that went well. And in July, they submitted a letter saying that they, would not object as long as those assurances that were made to them by the Springers came to fruition. And unfortunately, and again, I just want to reiterate that my clients have had nothing but nice things to say about the Springers throughout this, but that's not what this is about. This is about whether the Springers application meets the criteria for the special exception. And I don't believe that it does. And not only does it not meet it for criteria E, which I think has been discussed, but I understand that you haven't had a chance to read the letters that were submitted within the past 24 hours. And we submitted a letter, and I would ask the board to look at that because there's a lot of information there. And Brian, I'm not sure if you're able to pull up the video I sent, but if you could pull that up, I think that would be really helpful. It's a like 3 to 5 second video.
I don't think I have the ability to do that.
Okay. Well, I would actually ask that the board members take a moment to look at that before reaching any decision tonight, because what that video exhibits is, as you may recall from the previous letters, the Springers built an illicit shed that was unpermitted, which I understand is not part of the discussion. But what makes it part of the discussion is that it was a shed that was built to house and maintain their farming equipment and items related to their farming operation. That shed has caused substantial runoff and erosion onto my client's property. The Springers have said that they would help fix it, but that has become nothing more than them saying that and not following through on it. And it's been very difficult for my clients who have had to clean, drain, and refill their pool on multiple occasions this summer. And the video shows very well how bad this issue has become during a recent rainstorm about a week and a half ago. And I would say that under criteria A and C, I don't think that can be met here because the operation has created a sedimentation or erosion issue or an adverse effect on water supplies. Building something as part of your farming operation that causes your neighbor's pool to have to be drained multiple occasions impacts water supplies. And I think it could also be said that it's unsanitary and unhealthful as well. And I would also like to note that no one is saying that growing vegetables or having flower gardens is bad. That's great. The difference is that the Springers have applied for a special exception to be able to have 5 employees. And I know Ms. Shoup isn't here today, but as she mentioned at the last meeting, it is concerning that, people would be able to look outside and see 5 employees essentially in their backyard. And I understand that Ms. Springer has explained that it's not like 5 full-time employees, but it's still an application for 5 employees. And I think that does go to the fact that it is okay to consider the scale here. And I would actually say that, under Maine case law, there is extensive case law in Maine that says that the board is well within its right to consider its own personal knowledge, its own personal experience, and also the input of property owners who can testify to the value of their property and concerns about that. So I would just say that the Springers are great people. No one is disputing, at least my clients are not disputing that. That has never been an issue for them. The issue is what's in front of this board. And I would say that the only evidence that's come up since then, and again, I would ask that you watch the video and read the letter thoroughly, is that it's actually less likely that they'd be able to meet the criteria. So I think it's important that this board, keeps in mind, I have a hard job as a lawyer. You have hard jobs as board members. Our job isn't to think about whether or not someone is a good person. It's to think about whether or not they can do what they're asking to do. So thank you very much.
Thank you very much. Yeah, Mr. Crockett?
Yes.
Point of clarification, we've been dealing with this for 3 months. You folks brought up the initial erosion or sedimentation the first month.
Yep.
Has any of that been remedied at all?
No, they provided sandbags, I believe, but as you'll see from the video, that's not even close to doing anything. They've said that they agreed, but my understanding is that those conversations have essentially gone nowhere. No efforts have been made unless my clients have put forth the effort, and the response has essentially been, well, contractors are backed up. And previously, when we submitted the letter in July, the agreement was that the illicit shed would be removed completely and that the Springers had told my clients that they would pay for the remediation of this issue. After the denial in July, that was, well, we'll remove part of the shed and we can talk about splitting costs. So it is frustrating and it is difficult for them to deal with this.
Mr. Chair, in light of that evidence, I think we should probably take an executive session and review that if we can downstairs. There's no way to review.
I don't think that's necessary. Not
Okay,
for this.
well,
This is-
what she was trying to tell us was that she has pictures of the pool
So I believe that the video would have been sent to the board. I'm not sure if anyone can confirm whether that happened. It was sent with our letter.
It was received today.
It was-
Once and for all, Mr. Chair, yeah, everything that was sent to us.
Right.
Was forwarded to the board.
Right.
I cannot.
Oh, I
determine
completely
if the
understand.
Board saw it. It was all forwarded.
I-
We forwarded everything. Believe me, there was voluminous amounts of.
I
emails.
believe you. I'm
We
not,
forwarded.
I just
I
was,
can't attest to whether anybody saw it. I don't know that. Everybody works. I don't, like, except for Mr. Bork, everybody works.
I completely understand. I just was gonna say if they had it, then that Mr. Crockett could watch it that way.
No,
Not,
thank you very much.
Mr. Hebert,
Yes, Mr. Bork.
a question for,
Okay.
if the Springers were to agree to remove the shed as an additional condition, would that satisfy your client?
I mean, I think at this point, an additional concern is that there's already been these erosion and sedimentation issues. And if they were to do that and do all the things they previously agreed to, then yes, I don't, but I think it does go to the, yeah, that's the issue. If there was, unfortunately, the requests and the agreements haven't come to fruition or been dealt with adequately at this point. So the goal would be to have that taken down to the extent necessary, paid for by them, not by my clients, and have the remediation dealt with. And again, it is directly related to the farming operation. So I do want to make that clear.
Thank you.
Good evening, everybody. My name is Paul Johnson. I live at 78 Mitchell Hill Road. I am not an abutter. I did grow up on Aston Drive, which was right next to Maple Avenue. So I spent many of my childhood back in the day. You could start at Meeting House Farm Road, take your bike or your skateboard, and you could go down the hill and go right in Maple Avenue, right? So you didn't even have to worry about the cars hitting you, right? So I don't know if anybody remembers that, but I would start at the farm, jump on my bike and boom, right through it. Now there's about 14 stop signs, so you can't. I did spend some time in Miss Floyd's driveway growing up, playing some basketball with her son. So I know the area a little bit. I have visited the farm myself, and speaking specifically to Meeting House Road Drive, it is the best trick-or-treating in the town. So kudos to everybody that lives on Meeting House Drive. You guys are awesome. So with that being said, I don't, first of all, this is an R2 zone. This is an allowable use if they follow the process. They're following the process. I guess I would say on a personal level, does this fit the character of the neighborhood? This is the character of the neighborhood. There is a second neighborhood that is behind Honeywell Road, which is Meeting House Road, which I love that neighborhood. But really that neighborhood is a direct result of the untethered growth that this town has experienced in the last 10 years. And it's not the Honeywell neighborhood. It's its own separate entity. It has its own character. It has its own vibe. It certainly has its own different size housing. It certainly has its own different property values. It certainly has its different lot sizes, but it's not the neighborhood that we're talking about. The neighborhood that we're talking about, the cornerstone of that neighborhood is the Meeting House Farm Road. So unfortunately, when I sit up here, when I think if we're debating E, which in my opinion, that's all that's up for debate here, E, all the boxes on E have been checked. But with that being said, I feel like there is not a whole ton of disagreement up here. There's a lot of neighbor stuff going on here. That's a little weird, right? But really, there's not a whole lot of disagreement. Ms. Clary said herself that the original application has been incredibly scaled back and that there is been a good faith effort to compromise on what's going on. So to me, does this check E? Yes. Have there been compromises to make this work? Yes. Do I think that there's some stuff going on in the neighbors that need to be separate from what's going on right now? Yes, and those need to be dealt with. On a side note, I am the chairman of the Scarborough Town Council. Okay, this is going to go before the ordinance committee. This needs some cleaning up. In my humble opinion, that this farm actually fits the definition of an accessory farm more than a commercial farm. I'm not a code enforcement officer, but that's the way I view this. We have some work to do. And I guess I'm here saying to everybody in this room, we will do that work. But in the meantime, we got to let the people have their farm, a very scaled back farm that checks all the boxes with a straight face. And we'll try to straighten some of these definitions out and we'll look at the R2 zone and see if we can do something about it. But this isn't the place to scream and holler at each other. It's the place Does this fit E? It fits E. Thank you.
Thank you very much. We're actually, ma'am, were you next, ma'am? No, either or.
Thank you. Scott Springer, 35 Honeywell. So, thank you to the board. Thank you to all the community members, both pro and con here. Obviously, there's a great dialogue going on, a little passion coming out here too. It's been quite a journey, really it has. Yeah, we're navigating through this like everybody else. Like coming into this, we're thinking, what do we need to do the right thing here, right? To come in front of the community and come in front of the board here and make sure that what we're doing is above the line, recognized that way, right? Through that process, like was mentioned tonight, we started with an initial proposal, right? And all along, the guidance that was given to us was to listen to the board, listen to the community. That's what we've done, right? And that has caused us to scale it back and scale it back again, right? And we are here tonight to have that open dialogue to figure out how to make this work. We do want to fit in the community. We don't want to disrupt the community. Like I said in the first meeting, we want to be that community. We want to be a center of that neighborhood, right? And that's what we're trying to foster here, right? We don't have a huge industrial farm. We're not commercial agriculture. We are a small garden setting, right? Where my wife and her small team, they hand pick flowers, they hand pick leaves, they dig up roots and they dry those, right? It's a very small, unintrusive operation. So I want to make sure that that is made clear. And I'm very proud of my wife and what she does. I'm very supportive, right? It's been hard on all of us here as we've worked through this. And to Shay and the Bernsteins, I don't know if Shay's still here, but you know, there are some things that we need to remediate, right? The one thing that we haven't set with them is a time frame, right? So I think the Bernsteins had a quicker time frame than we had, and I think tonight, you know, we could agree to what that time frame is and work with that if that's a condition of approval. There were statements made that no remediation has happened to this point. That's unfortunately not true, right? So we've built a swale to stop the runoff. That on July 20th, there was runoff that did go into the pool, but I don't know if anybody was part of the inch an hour deluge that came through. It was just an astronomical flow of water, right? Not much could stop that. So we continue to open a dialogue and talk to and communicate with the Bernsteins and working through what that will be in terms of remediation. If it's decided to take down the shed, okay, I'll take down the shed because I fully support my wife. I fully support what she does. That's way more important than a shed that I built, right? We have been working with the town. We've been working with Brian Dobson for a while to work through, okay, what does that shed look like to get the permit in place to make sure that we are within code. So taking the final steps there. So there has been process to remediate the Bernstein's issues. We still have a way to go, a couple steps to go, and we'll make sure that we'll do that. And then, you know, in terms of, you know, the people here, I want to thank you all for coming out and supporting us. It's been a healthy dialogue. In some cases, it's been an unhealthy dialogue. So unfortunately, during this process, we felt like there was some defamation going on. So that's why we had to bring character witnesses here. But, you know, thank you for your time and thank you all.
Hello, my name is Logan Donahue. I am a direct abutter at 29 Meeting House Road. We are here again. We've been to every meeting that has been held. We sat online for the 5-hour meeting. You know, it's important to remind the board that this process started in November. It had public comment in June. People were not re-notified in July about the July meeting. There was sufficient public comment offered in June without new notice of the July meeting. There was opportunity for people to share. It's also important to remind the board that we're here focused on the criteria. We're not focused on people's character. This isn't a personal situation. You know, we don't have anything against the Springers. We don't have anything against farming. We don't have anything against entrepreneurship. You know, it's a business that was created before they had the appropriate zoning to do that. We're not trying to shut down somebody's business. We just live here. You know, we purchased a property in a residential neighborhood. To say that it's not the same neighborhood as Meeting House Farm is in is a little bit jarring. We are direct abutters. Our entire back property line directly abuts the farm. It's the same neighborhood. Meeting House Road is directly abutting Meeting House Farm. It is called Meeting House Farm, even though it lives on Honeywell Road. The traffic concerns still exist. The business can scale regardless of the current intent. It's currently an organic farm. It could turn into a non-organic farm that does have loud machinery, that does have more employees. It's very important to keep that all in mind. I know there's been comments about the consignment business. It was my understanding, based on that or not, seems to be something that was questioned. But I think there still is some distribution that's happening from that when orders are placed. It's important to keep in mind that those who do directly about the property are here and dealing with it every day. We don't just walk by it, it's directly in our backyard. While we aren't entitled to a view, people do very different things when it's for a profit versus a personal garden. People aren't going to spend the same amount of time and effort on a personal garden if they have to also work their 9-to-5 job. It's, you know, while it's relevant that somebody could farm their entire property, they're not traditionally going to do that if they're not trying to make it a business. There's a difference between what is an allowable use of a small farm stand to sell your overages and a commercial business with a website that's marketing and attending events to try to grow their business actively. You know, we purchased in a residential neighborhood. We have young children. We chose to do that because it was a quaint neighborhood with an R2 zone and sidewalks, and that road, regardless of how many employees you have, it's still bringing additional employees, not for the purpose of a residence. It's still a business. Thank you.
Thank you, Logan. Sir?
Thank you. My name is Andy Happel, and that's Happel. I live at 4 Overlook Drive with my wife, Margaret Logan, who I believe has already spoken. This is the first meeting that I've attended, and I'm very happy to be here. I just got here about 10 minutes ago, so I don't know everything that's been said in previous meetings or even tonight. But a couple of things that I did hear tonight, just in the last few minutes, saying that someone's character really doesn't have anything to do with what we're talking about. I don't know the codes, I don't know the law, but I believe that a person's character has a lot to do with things. I think that's valuable. I think that's something to be considered personally. That's my opinion. We directly abut the Springers behind. We're at 4 Overlook, and our back property line abuts the Springers property line. And what great neighbors. They're just great people. We never hear them. We never hear machinery. We see them walking the boys or the dog or skiing through the back, but we don't hear them. I think that the notion that in the future they would bring in some kind of loud machinery is nonsense, in my opinion, because they would be held to pay. Look what's being said. They would know what was coming if they were to choose to do that and bring in some kind of machinery. They know that it wouldn't fly. They know that people would be upset. That's not going to happen. But they're just good people. They've restored the house at Honeywell Drive. First of all, I would also like to say, I feel like it's all one neighborhood. We may be off of the Meeting House side versus the Maple Ave side. We all walk all of the streets. It's one neighborhood. I don't feel a separation between the Meeting House side and the Maple Ave side. When we walk by, if Mr. Springer is mowing the lawn, he stops. He turns the machine off to stop and talk to us. It's just a pleasant corner to walk by. They're pleasant people to talk to, and that means something. For me, our daughter is 15 now, so we didn't have the chance to stroll by a little farm like this and point to the chickens, or maybe when there are things for sale in the garage, stroll in and look at the herbs or whatever it is that they're going to grow and sell. But what a beautiful thing. What a beautiful project. This little organic farm, and it is little, in the middle of a neighborhood with the opportunity for parents and kids to stroll by and look at this stuff, is just a beautiful thing. I think it's wonderful. And so I want to speak in support of that. Thank you.
Thank you very much. Is there anyone else?
I'm Jeff Jones. I represent Max and Logan. Donahue, and Logan's already spoken, but I did send a letter on behalf of my clients on Tuesday. And I just want to make sure that I won't reiterate it if the board's already had a chance to review it. But at the beginning of this motion for reconsideration, I did not hear any discussion as to what the basis was as to why the board was reconsidering this application, which has been denied in the previous month. As you know, this matter has had 2 public hearings. Now it's on its 3rd. So I'm not sure that was the basis, but it's my understanding that Robert rules apply to the town and town committee and board meetings. And under the Robert rules, only members who have voted in favor of the underlying action are allowed to make the motion for reconsideration. That the losing side, the people who voted in this case to approve it, aren't the people that are allowed to reconsider it, bring the motion reconsideration. It's only the people that actually were voting in the affirmative. So, and that didn't happen tonight. So we do object to that. But the bottom line is we heard legal argument tonight from counsel, but there's no new facts. There's no new evidence before this board. There's more people that speak to the character of the applicants. But as far as application and what was presented in July and what's presented tonight, it's the same. There's nothing new. And so there's no basis to reconsider and to change votes. And it sets a very dangerous precedent for this board, because that's going to happen. You'll see it more and more, and your agendas will be, you'll never be able to finish projects because everyone's going to be filing motions for reconsideration if they lost. Why wouldn't you? And hope that next month there's a new board member who's missing, who is voting in your way, and now you can take a new vote, and with an alternate, you have a good shot. So I think it just sets a bad precedent for this board, and I think you're going down the wrong road. If there's something new that changes it to some newly discovered evidence, something that wasn't known or couldn't have been known in July to the applicant, that's one thing. But this is just a situation where they just want another bite at the apple, and that's it. And I think that's a dangerous precedent. Thank you very much.
Thank you. And just to speak to your one point about the reason for the reconsideration and the predominant reason, the dominating reason that we are here tonight for a 3rd month in a row. Unfortunately, due to the technical difficulties last month with not having the online system functioning, we weren't allowing due process for the folks who were at home anticipating on participating in the meeting that was guaranteed by the town's website. Unfortunately, due to the technical difficulty, that option was not available to folks. So in order to provide due process to allow this public comment to take place, this is what the dominating reason why we are here tonight. And it is certainly the exception and not the rule. Is there any further public comment? I see the attorney representing the applicant is here. If you would like to address any of the comments here before we move on, you're free to do so.
I'll be brief, as this board's heard enough, but I want to address a few things. First, I'd like to address the Bernsteins and their counsel, Shay Watson. We are willing to agree to remediation efforts for the shed. I will say the shed is not part of the proposed use. It's not used for the farming operation. It's not used for the proposed use in the application. It simply has some shovels in their lawnmower. They mow their lawn with there, I believe, but it's not part of the application. It's not part of what they actually use. With that said, my clients will agree to remove the shed and pay for any remediation efforts on behalf of the Bernstein so that the flooding is taken care of. And I'd also like to reiterate, July was an albatross. It was an unusually large amount of rain that no one would have anticipated. Unfortunately, those things do happen. With respect to Attorney Jones, in all due respect, there has been new information. We had realtors ready to come and testify at the last hearing. They were unable to for the reasons Mr. Herbert just elicited. They were online, ready to come in, and they weren't able to. We've submitted that evidence to this board. With respect to the specific standard criteria E, which is an issue here tonight, it's compatible use for the neighborhood, visual impact, things of that nature. I think you've heard plenty of testimony, that's new testimony that you didn't hear, that more than supports the proposed use. So I'd like the board to take that into consideration and bear in mind that there was actually many additional things put forth before this board for its consideration. And we respectfully request that you approve our appeal, and we really appreciate your time.
Thank you. Mr. Longstaff, do we have any additional letters or emails that we have not reviewed or had not received until this moment that we'd like to read into the record?
Everything that's been forwarded to the board.
Great. Thank you, Mr. Karen.
I just, through the process, are there any viewers online that may have questions?
Thank you, Rudy. Want to check? Brian?
I've checked for participants and there are no attendees that are raising their hand at this time.
All right, thank you. Seeing that the public hearing floor is closed. So now we will deliberate amongst ourselves and the board, and there will be no further comment from the public at this time. So thank you all very much for your participation. So in looking for the board, we will go through each of these criteria similar to the previous application that we reviewed and discuss whether or not information provided tonight will have changed your minds or change your thoughts or opinions or findings of fact on previous statements made for these items. So A, the proposed use will not create unsanitary or unhealthful conditions by reason of sewage disposal, emissions to the air, water, or other aspects of its design or operation. And I'll start with you, Rudy. Does any of the information here tonight change your vote on this item last month or the previous month?
All right, thank you, Mr. Chair. No new information would change my previous understanding and vote on this matter. It was provided this evening that some concerns on site were unrelated to this proposal. And there were some potential agreements made that would rectify any issues there.
Thank you. Mr. Fralinger?
I'd reiterate Mr. Karen's comments. I'd also add, though, that we had a list of stipulations. I think the board had considered at the prior meeting. And it might be appropriate to add that remediation step that had been discussed by the attorneys as part of an additional stipulation item. But otherwise, nothing further.
And speaking to that, I have a list of those items and we'll discuss it when we get to that point. Mr. Crockett?
No, I haven't heard any new information that would change my voting on.
Okay, Mr. Bork?
Nothing new.
Okay, and I don't see anything new either. I mean, this is organically grown plants, and the issues that they have with water remediation that they are currently addressing at this point based off of a shed, I think the board would agree that whether the shed's being used for this possible commercial operation or if it were just their personal shed that they're just storing buckets and a lawnmower and gas in, it wouldn't be any different from a shed that we have at home. Is that, would the board be agreeable on that? Okay, so we'll go up and down vote on that one. Rudy, how do you vote?
Aye.
Mr. Freilinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I will vote aye as well. So letter B, the proposed use will not create unsafe vehicular or pedestrian traffic conditions when added to the existing and foreseeable traffic in this vicinity. I'll start with you again, Mr. Karen.
All right, thank you, Mr. Chair. I'm just rereading. I do not believe I've heard any new testimony this evening that would change my previous vote.
Okay, Mr. Fralinger.
I have actually the clarifications offered by the Springers regarding the nature of what processing is on the property and the number of employees that would exist being equivalent to one full-time employee as opposed to the 5. There might be 5 people, but not 5 full-time staff. I think that clarification is new information to me. That was not clear in prior discussions. So I would be in support of this one in having not been done so in the past.
Thank you, Mr. Crockett.
Yeah, based upon the information we've heard tonight, I think they spoke of 1 employee. So 1 employee is different than 5 employees. And there was an accident over there. Obviously, that could happen any place. But based upon the guidelines that we're given now with the 12 steps or 13 steps it may be that were outlined in the previous information from one of the abutters, I don't think if it's just online only, and there's no traffic coming there and just one employee, that it's going to create an unsafe vehicular or pedestrian traffic the way it's presented right now.
Thank you, Mr. Bork.
We did hear additional information tonight from people in the neighborhood. And really the reason that we are reconsidering this particular proposal is because we weren't able to hear from everybody last time. So we did hear a lot of people saying that traffic really isn't a problem here. Yes, occasionally there's traffic, there are accidents anywhere, it can happen. But certainly nothing that the Springers themselves are causing. And I think that's really a key point here. So nothing has changed, my opinion.
I'll admit this one has always been a concern for me as far as traffic. Anytime you work without a home occupation or any kind of commercial business at the property. But given that the applicants have stated that there will be no customers coming to the location, they're agreeable to a restriction that would not allow any street parking or other folks to go there. Any vehicles have to be in their driveway. It wouldn't be necessarily any different from folks utilizing their own home to have guests over at that point. So with regard to this particular criteria, I agree as well. Mr. Karen, up and down vote.
Aye.
Mr. Freilinger.
Aye.
Mr. Crockett.
Yes.
Mr. Bork.
Yes.
And I'll vote aye as well. Letter C, the proposed use will not create public safety problems, which would be substantially different from those created by existing uses in the neighborhood or require a substantially greater degree of municipal fire police protection than existing uses in the neighborhood. Has anything here changed your thoughts or opinions on this criteria, Ms. Karen?
No, Mr. Chair.
Mr. Freilinger?
No, I'm still good.
Mr. Crockett?
No, nothing new to present on this to change my prior
Yes.
vote.
Mr. Bork?
No.
No, and this doesn't appear to apply. That's right. I support this as well. So yes, that is letter C. Letter D. Oh, excuse me. I'm sorry. Mr. Karen, how do you vote?
Aye.
Mr. Freilinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I vote aye as well. Excuse me, forgive me. Letter D. The proposed use will not result in sedimentation or erosion or have an adverse effect on water supplies. Mr. Karen.
I want to just mimic similar comments I made previously on A with regard to the shed of concern not being part of the application, but potentially dealt with through restrictions that will later be discussed.
Mr. Freilinger.
But same comments. We'll talk about the restrictions later, but nothing further.
Mr. Crockett.
I would stick with my prior vote on this. I believe that it has created sedimentation, but nothing new.
Mr. Bork.
Nothing has changed my vote.
I understand the argument of the shed. However, as pointed out by Mr. Karen and noted earlier, the shed doesn't have any bearing on the functionality of this farm. And it's already been discussed between the two attorneys and the two attorneys in question, the applicant and the abutter who's raising the issue, that they're going to be mitigating that themselves. So I see no issue with this one. Mr. Karen, your
Aye.
vote. Mr. Freilinger.
Aye.
Mr. Crockett.
No.
Mr. Bork.
Yes.
And I'll vote yes. That's 4-1. Letter E, the proposed use will be compatible with existing uses in the neighborhood with respect to physical size, visual impact, intensity of use, proximity to other structures, and density of development. Mr. Karen, your thoughts?
Just want to say that personally, there was new information and testimony that was presented this evening that was not heard previously, but none of which would impact my previous one.
Okay. Mr. Freilinger?
Yeah, I think there has been new information, and I'll point out that there has been a journey on this appeal, that we're not facing the same appeal that we did 2 months ago, certainly. And information has made it such that this appears to be more in keeping with or not more in keeping, I shouldn't say that it is compatible with the existing uses of the neighborhood. If we look at what any a homeowner with a 2.5 acre property could do in terms of creating their own garden, that they could create a space such as this. And that would be compatible with the R2 district. So I feel that new information that has restricted the other elements of the commercial property that we first heard 2 months ago makes me comfortable now that this is now a compatible use and that it wasn't in the past. So.
Okay, thank you. Mr. Crockett?
I haven't heard any new information on this. I would stick to my prior vote on this. I'm concerned that the town really has no way to regulate it, going with concerns of the neighbors. Granted, you can make this, if you've got a garden, you can do it on your regular property, whether you don't sell it or not. But there's really no way to limit the visual impact or the physical size. I mean, this could be highly developed, 100% developed, and there's nothing that anybody can do about it.
Mr. Bork?
I voted yes on this one, as I'm sure a lot of you remember. And I've heard a lot of evidence tonight that reinforces my vote. First of all, I like to deal with the issue of enforcement. That's not up to this board to enforce. You know, that's code enforcement's job. And it's up to neighbors if they see something out of line to bring it to code enforcement. That's not our job. So we're not voting on that here. And tonight we've had the opportunity to listen to a lot of neighbors who have brought, good, solid information to help us see that the visual impact and the intensity of use are very compatible to the neighborhood. We've also heard testimony that there are other neighbors in the neighborhood, and I'm sure this happens everywhere, and not just in Scarborough, but in other municipalities, where people are selling things they're growing on their property. Well, there is a process for doing that. You have to come to the zoning board of appeals in that municipality and get permission to do that. And in this particular case, that's what they've done. The Springers have come here. They've really, started by going to Brian, when it was brought to their attention that they're out of compliance. So they came here to seek remedy. And I think they've done the right thing, through this process. I hope that all the other people out there who are running, flower stands or other things, as we've heard, will do the same, because we can hear those things and we can, grant permission where it's justified. So in this particular case, I don't say anything has changed as far as my prior opinion on this, that yes, they've met the criteria for this one.
Thank you, Mr. Bork. With regard to this one, and my thoughts on it, looking at it from respect to physical size, visual impact, intensity of use, proximity to other structures, and density of development. Intensity of use, they've already indicated this is a tilless operation. A lot of it's done physically by hand. They don't have any large pieces of farm equipment on their property. It's a small lawn tractor that is no larger or smaller than anybody else would have in that area. There's enough tension on this. There's enough attention on this property that should they try to upscale it or go beyond any kind of restrictions that the board would put on this property, someone would tell the town and enforcement would take place. I previously have voted no on this one, but I am going to change my thoughts to and vote yes on this one, only because my previous thought process was looking at this as far as a zoning change, and this isn't a zoning change because this is an allowed use within the R2 district. They just have to fill out this form and come before us for here. So with that being said, Mr. Karen, what is your vote?
Aye.
Mr. Frelinger?
Aye.
Mr. Crockett?
No.
Mr. Berwick?
Yes.
And I'll vote aye as well. Letter F, if located in a shoreland zone, Mr. Longstaff, you confirm this is not in a shoreland zone?
This is not in a shoreline zone.
Okay. Mr. Karen, vote up and down. Do you agree?
Yes.
Mr. Frelinger?
Yes.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I agree as well. Letter G, the applicant has sufficient right, title, or interest in the site of the proposed use, able to carry out the proposed use. Mr. Karen, up and down, or Mr. your thoughts first.
Sorry,
please.
I haven't heard anything that would change my previous vote.
Excellent. Mr. Frelinger?
Yeah, agreed.
Mr. Crockett?
Nothing new.
Mr.
Agreed.
Bork? And I agree as well. Nothing new to add here. Mr. Karen, your vote?
Aye.
Mr. Frelinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I vote yes as well. H, the applicant has the technical and financial ability to meet the standards of this section and to comply with any conditions imposed by the Board of Appeals pursuant to subsection 5 of this section. Mr. Karen?
To start, I haven't heard anything new that would change my previous votes. However, I do just want to say that we will be discussing any restrictions or conditions as we move forward.
Mr. Fralinger?
Nothing further to add.
Mr. Crockett?
Nothing further.
Mr. Bork?
What I heard tonight is that the applicant has agreed to comply with all the conditions that we added onto it, including the new one, which was to remove the shed at their cost. We didn't know that last time.
Excellent. And I'll adding on to that as well, they have stated that they are willing to work with any conditions imposed by the board for this. So I also agree. Mr. Karen, your vote. Mr. Longstaff, you wanted to say something? Mr. Crockett? Excuse me, Mr.
That's
Karen?
Aye.
Mr. Fralinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I vote yes as well. Letter I, and I believe the last one. The proposed use will be compatible with the existing uses in the neighborhood with respect to the generation of noise and hours of operation. Mr. Karen, your thoughts? Does this change anything based on the information you've heard tonight?
No, this would not change my previous vote or what I've heard this evening. However, as Mr. Bork previously said, several of the conditions or restrictions may speak to this as we move forward.
Excellent. Thank you. Mr. Fralinger?
Agreed. I think that what we've heard additionally in terms of the scope of the operation, the clarifications we got from the Springers, and also the discussion from the neighboring abutters and neighbors in general. I don't remember whether I voted no on this at the last one, but I would feel comfortable voting yes today.
Mr. Crockett?
Yes, if there's no noise or hours of operation, which there doesn't seem to be with one employee, and no cars or traffic or anything being brought to the site or anything like that, then yes.
Mr. Bork?
Nothing new.
I'll just add that it was mentioned last month during the meeting, but also I'll reiterate again here. Their employees have maximum up to 5. They would be willing to have them in their driveway between the hours of 8 a.m. and 5 p.m. on a Monday through Friday basis. Just wanted to point that out for the board, that they'd be willing to accept that restriction. Excuse me? Yes?
So are you motioning to accept the previous restrictions that were outlined by the attorney?
We are not going to that stage yet. No, we will be imposing our own restrictions. And if they want to impose additional restrictions on themselves, they can work that out. Mr. Karen, your vote?
Aye.
Mr. Fralinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I vote yes as well. So what I'm going to do at this point, I'm going to make a motion, and I've written down 6 restrictions. I understand those aren't the restrictions that were a part of the abutters attorney's recommendation for restrictions, but I think it's best if we have our own set of restrictions here. It's clearly that there's a relationship going on between those 2 abutters at this point, and if they want to work out additional items at that, if they want to work out additional restrictions and negotiations between the 2 of them, they can do so at that point. So what I will do is I'm going to entertain a motion. I'm going to state the entire motion, and I'll just need someone to so moved and then a second. Oops.
Pardon me, Mr. Chair, just for my clarification
Yeah.
about what is to occur. At the previous July meeting, there were several suggested conditions. And I guess I should just wait.
I'm going to list off the ones I have here, and if we want to add more, we can make an amendment to it.
All right, thank you for the clarification.
Well, let's see how this goes on the first try. So I move to approve appeal number. I entertain a motion to approve appeal number 2711 with the following conditions. 1, no more than 5 vehicles in the driveway at 35 Honeywell. Intended for employees only between the hours of 8 a.m. and 5 p.m. Monday through Friday. 2, no vehicles will be parked on the street. All vehicles must be in the driveway. 3, There will be no drive-up sales. All sales will be conducted online, and the physical exchange of product must take place off premises of 35 Honeywell Road to further avoid any considerations or concerns of traffic in that area. 4, no public classes are to be allowed on that site. 5, no growing of cannabis or cannabis-related products. 6, remediation of the I guess I didn't write this one out correctly, excuse me, remediation of water damage caused by the shed. So moved.
So moved.
Do I have a second?
I'll second.
Okay, now we're in the discussion phase. Are any additional, do we have comments on those amendments? Excuse me, do we have comments on those restrictions? Are there additional restrictions that we want to put on here before we and also continue discussion and vote as well? Mr. Crockett, I'll start with you, then go to Mr. Freilinger.
I'm just trying to find what the criteria was that the neighbors had put down and had said yes to. I thought there were like 12 or so.
There were 13, and that was in
Do we
last
have
month.
that any place?
We do, it's actually in the minutes.
In the minutes from last, yeah.
Yes, Mr. Chair, they're in the minutes. I think they're accurate. I wasn't here, but in reviewing the video, I believe they're accurate.
On page 3.
Mr. Chairman, on that note, I think the one that I would make or would propose an amendment to is the non-expansion of the business into animal products and no farm animals except for chickens.
Okay, then I will entertain an amendment to this to add item number 7. This will be no expansion of business into animal products and no farm animals except for chickens on site. Do I have a so moved?
So moved.
Okay. And a second, and all those in favor of the amendment being added?
Aye.
Sorry. Mr. Karen?
Aye.
Mr. Bork?
Yes.
Mr. Crockett? We can add more amendments as well in addition to this one.
Okay, I'm just trying to read through the ones I have still, so.
Sorry about that.
You want to vote no?
Yeah, if you don't, sorry, just on this one about the animals and animal products.
Yes.
Thank you. And I vote aye as well. Additional discussions? Is there an additional item that you would like to add, Mr. Crockett, to the list of restrictions?
Can you give me yours again, your 6 that you have?
Yep, the ones I have listed are no more than 5 vehicles in the driveway. Employees operating between the hours of 8 and 5 p.m. Monday through Friday. No vehicles to be parked on the street. No drive-up sales. All sales have to be conducted online, and the physical exchange of product must take place off premises to avoid further traffic. No public classes allowed on site. No growing of cannabis or cannabis products. Remediation of the shed. And number 7, when we just added, no expansion of business into animal products and no farm animals.
Mr. Chair?
Yes, Mr.
We're
Bork.
open for discussion on these.
Yep, we are open for discussion right now.
Regarding the one on parking, the original one that we had from last meeting talked about maximum number of 5 employees. Oh, excuse me. Let's see.
They indicated that they would necessarily have all 5 at the same time, though they could.
No, the key point that I want to make, though, is they should be designated parking spots. Is the way that was worded in the original one. And yours wasn't quite worded that way.
No,
Is there a reason?
I don't necessarily think we have to get too deep into the weeds on that one. That's why I'm saying 5 vehicles in the driveway at
I was
35.
thinking from enforcement point of view, if there are designated parking spots for employees, it's much easier for anybody to see how many there are.
That's true.
As opposed to if they're just scattered all over the place, it's impossible.
I guess to me, I wouldn't see the difference between that and like a personal or a personal visit from family or friends or something. Mr.
Well,
Longstaff?
that's what I was going to say. I think to Mr. Bork's point, and I'll just bring this up for discussion, if you actually had designated employee parking, it's possible that an aunt and uncle, a relative might want to come and visit, and there might be employees. How are you going to tell who's there for the employee the allotted amount of employees versus others. But if you had designated parking for employees, if the Springers were willing to make that happen, then it would be a much easier thing to enforce. And while I'm on the topic of enforcement, I do take exception to the fact that it was mentioned a dozen times that the town can enforce conditions, and that's entirely untrue. And I'll take the opportunity now to say that that's just completely untrue. What the town can enforce is conditions that are unverifiable. So as you go through these conditions, I appreciate the fact that the board is considering whether or not these conditions can be verified. And that's very helpful. And it's important to have conditions on these special exceptions because that's what makes them meet the ordinance requirements as opposed to just letting things go all over the place. But again, I just bring up that maybe it might not have to be, but designated parking spots might make it easier to tell employees from relatives and friends, which they're certainly willing and are certainly permitted to have people visit them who are coming as family and friends, not working in the farm.
Right.
Pardon me, Mr. Chair.
Yes,
Would it be
Mr. Chair.
possible to entertain an additional condition of the original number 5? No new structures on the site without site plan approval?
Well, you don't have to entertain. You can actually make a motion for it.
Okay, that's fine.
As the chair, I'm not allowed to make a motion. I
That's
can only
fine.
entertain a motion.
Well, at this time, I'd like to make a motion to add that additional condition, no new structures on the site without site plan approval.
Okay.
I'll second it.
That's a second from Mr. Fralinger. All those in favor, Mr. Karen?
Aye.
Mr. Fralinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I will agree as well. Mr. Crockett?
In addition to that, I'm looking at ones, I don't think you mentioned these, but I could be wrong. You had said no classes. One of the original things that they had agreed to from the other abutter was no events. That's different than classes.
Okay.
And then it looks like the farming operation on site limited to flowers, herbs and vegetables. I know you put the no cannabis or hemp products in there,
I did,
but I
yes.
know their original one was the farming operation on site limited to flowers, herbs and vegetables.
I mean, the thing is, because we already had the amendment that doesn't allow animal products, I guess what's left after that?
Okay, I'm just putting it out there.
No, I appreciate it. No, I certainly do.
And then there was a 50-foot side setback, rear setbacks to buffer the neighbors from the noise, dust, water runoff, and other farming operations. Those are the ones that weren't mentioned with yours.
Yep. Would you like to add any of those? I did not include the 50-foot side and rear setbacks. I think that's unnecessary. But that's my opinion. Any board member can make a motion to amend it to include this or not, and we'll discuss it and vote it up or down.
I would concur, Mr. Chair, that that's not a necessary amendment to add.
Okay. Any other to Mr. Fralinger?
No, I'd agree with that as well. I don't think it's necessary.
Okay.
Then in that case, the only one I would add to it is no events for the public.
Why don't we do this? I'll entertain amendment to adjust the item number 4 that said no public classes allowed on site to read no public classes or public events allowed on site.
That's agreeable.
So moved.
Second.
Excellent. Vote, Ms. Karen?
Aye.
Mr. Fralinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
And I'll agree as well. Any other discussion on this?
I just have maybe a clarification question. At this point, hearing some of the added amendments, would it be appropriate moving forward to perhaps, for consistency's sake, recall what was proposed at the July meeting in the same numerical order as the conditions were read? Just this evening, there was a little bit of a
I mean, I don't think that's
that's not
necessary.
necessary. Okay.
I don't think so. I mean, I've listed them off here. We've stated them on the record, and Doreen and Brian can make sure those are typed up, and then we'll have the opportunity to back check those during our meeting minutes and approval of the findings next month at our next meeting.
Okay, thank you.
Mr. Crockett?
So we've added a lot of amendments to your motion.
Mhm.
Should that be all one now listed as one amendment, or do we?
Oh, no.
When we voted on
this-
all these separately, it's just going to be.
This is all under, we're still in the discussion of the motion to approve this appeal. And these amendments that we're adding are all the list of restrictions that we're adding onto this. So if there are no further amendments or restrictions that we wish to put on it, we can do a vote on the entire appeal as it stands now with all of these restrictions that we have now put in place.
Pardon me, Mr. Chair, I'd like to add an additional motion,
Yeah.
condition.
Yeah.
It was discussed that the two parties were agreeable to the removal of a shed that was causing the concern about the rainwater runoff, not in addition to any of the remediation. So I'd like to add that as well.
Okay. I had it as indicated as remediation of the shed. But yes, we can certainly do that. Make your motion for it.
Mr. Chair, I'd like the motion to add the condition, the removal of the storage shed that was previously discussed this evening.
Okay, is there a second?
Second.
Okay, Mr. Fralinger, how do you vote?
Aye.
Ms. Crockett,
Yes.
Bork,
Yes.
and Mr. Karen?
Yes.
And I'll agree as well. Mr.
Mr. Chair.
Longstaff?
So I'm just, again, I'm trying to make sure that, is it the board's intent that the shed be removed entirely from the lot? Or is it the board's intent that the shed be made compliant with the zoning ordinance setbacks and correct the erosion situation?
The intent here, and from my understanding, is that the shed can, the cause of the water issue in that area that requires remediation is due to the shed that's being installed. They've indicated that the shed can be removed to help remediate the water issues in that area. If the shed were removed, were relocated to a different part of the property in a legal location with appropriate setbacks, as long as it doesn't cause any further, any sort of sedimentation or erosion, it can stay.
Okay, I just wanted to be very clear.
Yes, no, I
Because there was, I think, at one point, and maybe still, a discussion on no new buildings as a condition. So I want to make sure that the board's intent is to correct the violation and remediate the erosion and sedimentation control issue.
Yep.
But not to eliminate the shed that as it exists, just to be able to relocate that to a conforming location on the lot.
Thank you. Yeah, no, and that is our intent. That is our intent.
And pardon me, Mr. Chair, just to clarify, a previous motion I made was no new structures on the site without site plan approval. So
Do you want to include that? You can if you make a motion.
I believe I had already done so.
Was
I
that
just
one?
was clarifying.
I
believe that
was.
in the motion, yes.
Thank you. Thank you. Any additional comments, conditions? Yes, Mr. Crockett.
Mr. Longstaff, just one quick question on the shed. Was that actually approved to be built before, or was that, or does that even
I
require
actually
a
don't
permit?
know the answer, but as I understand it, it's encroaching into the setback. And I think that's what's creating some of the issue. But we will work through that through the code office. I just want to make sure that, is it the board's intent to eliminate the shed entirely or to make it conforming with setbacks and locate in an area that's not going to create an erosion and sedimentation problem?
Yeah.
I don't know the answer to that, but we'll work through that issue.
Yep.
As long as I know what the board's direction is.
Yeah, the intent is if there is a way to make it conforming and not have a negative impact on their neighbor, they can put the shed somewhere else and be fine with it.
There's only one other issue that I'm not sure. I just want to bring it to the board's attention. I understand and I appreciate the board's or Mr. Karen's motion to amend, to add an amendment that says no new structures on the site without site plan approval. Is that correct?
that was a previous motion made, yes.
Yeah, yeah. So just so you know, agricultural buildings, I believe, are not subject to site plan approval. So we'd actually, I think it's okay to put that in there. I just want to bring that up, that this is not something that would normally be required. So, but I can certainly we'll put it in there and we'll enforce that until and unless somebody challenges that.
Understood.
Okay.
Thank you.
And that would be a legal challenge, you know, that would then, so we'll put it in there and it'll be a condition. You know, I believe that's already been agreed to. I just want to bring that up to the board's attention that you're actually requiring something that
Doesn't have to have that
wouldn't
site plan
normally be
approval.
required. I don't think that's a problem, but I
Yeah.
just want to bring it to your attention.
And granted, I don't think in the future, if they were to go forward and add another structure on that property, as long as it,
It'd have to
as
have a
long as,
building permit no matter what.
and it would have to be conforming.
Yes.
So that handles that
It's a
question.
language issue.
Yes.
Turn on. It's a language issue. So instead of saying site plan approval, it should say, you know, a building permit. Is that what you're saying?
No, site plan approval is.
I think the intent was for it to go to the planning board for site plan approval. That's where that
Yeah,
would
that was
happen.
the intent, but you know, is that practical is what I'm hearing.
I think it's practical. It's just that there's also under our site plan review ordinance, I think there's an exemption for agricultural buildings.
Yeah.
So it's, I don't know how that all
So
meshes,
it's-
but I believe the board still has the right and the ability to put that condition on there. And that, I'm not a lawyer, I'm not an attorney, but I believe that you have the right to do that. I just wanted to raise that issue that should that ever get challenged somewhere, I don't know.
Mr. Chairman, as a matter of practical consideration, I think the appellants had already discussed this with the Donahue's attorney and agreed to it as part of what came up last month. So I hear you, Brian, but I think practically it's probably fine as we've heard it.
Yeah, I think more or less we wanted to make sure.
I'm not disagreeing. I just wanted to make the board aware.
Understood.
Yeah, want to formalize it this way. Any other comments or discussion?
Yeah, Mr. Chair?
Yes.
Should we go through the performance standards or consider them as a whole?
Those don't apply to there.
Yeah, they do. Yeah,
Not a-
yeah, they do. For commercial farms on in residential areas.
The performance. Mr. Chair, if I may, the performance standards do apply to this use. It is not necessarily the board's purview. That's what we use to regulate anything that's out of compliance.
Right.
Those are the performance standards they need to
That was
adhere
my,
to. But it's perfectly fine if you want to take them up here, but that's more of the enforcement arm.
yeah, that's, again, I think that's why I understand they have to abide by those performance standards, but again, that's more on the town side to enforce them, not necessarily us. Okay. Further discussion? Okay. Seeing no further discussion, all those in favor of the motion as presented, Mr. Karen?
Aye.
Mr. Fralinger?
Aye.
Mr. Crockett?
No.
Mr. Bork?
Aye.
And I'll agree as well. Motion passes. Or appeal passes. Application.
I would like, just for the record, to be very clear, could the board reiterate the motion with all of the amendments, please, in one fell swoop so that we can get it right? That's a lot of stuff here and I want to make sure it's right.
Yep. The motion stated, move to approve appeal number 2711 with the following conditions of no more than 5 vehicles in the driveway. I'll going to summarize this just a little bit. No more than 5 vehicles in the driveway for employees between the hours of 8 AM and 5 PM Monday through Friday. No vehicles to be parked on the street. No drive-up sales. All sales to be conducted online. Physical exchange of produce and product must take place off premises. 35 Honeywell to further avoid traffic. Folks, we're still in session.
We're trying to. do
Yeah,
some
we
business.
still have some business here, folks. If you wouldn't mind, thank you. The motion as it currently stands is the no more than 5 vehicles in the driveway at 35 Honeywell intended for employees only between the hours of 8 AM and 5 PM Monday through Friday. No vehicles would be parked on the street. No drive-up sales. All sales would be conducted online. The physical exchange of product and produce have to take place off premises at 35 Honeywell Road to further avoid traffic, alleviate those concerns. There would be no public classes or public events allowed on site. There would be no growing of cannabis or growing of cannabis products. There would be a remediation of water issues by the shed. There was a removal of the shed. There was no structures on the site without site plan approval. And there's also no expansion of business into animal products and no farm animals except for chickens on site. Because that was part of that motion from last month. Is there any that I missed? And if I did happen to misspeak on there, now we can go back into the record because what we read is the actual official. So if I didn't if I did misspeak just now, the one that actually holds the true record is the one, our previous discussion over the last 10 minutes. Good. Okay. So at this point, we're going to move on to our agenda items that we delayed until this point. The first one is the, yes? 4-1. 4-1, yes. Mr. Freilinger, correct me if I'm wrong, you asked to have the approval of the draft written decisions moved before the remote meeting policy discussion. Is that correct? Yeah, okay, thank you. So Mr. Longstaff, for the approval of draft written decisions for 2710, 2711, we can't address those tonight because those are now different. We'll have to address those at our next meeting. Is that correct? Okay, good. So at this point, we're going to look at appeal number 2712, practical difficulty variance appeal. I'll entertain a motion to approve the draft written decisions that were submitted. Has everyone had a chance to review and take a look at all that information? And if there is any changes or amendments or edits or corrections? Mr. Karen?
No concerns.
Mr. Freilinger?
Nope.
Mr. Crockett?
No concerns.
Mr. Bork?
None.
And I see none either. All those in favor? Ms. Karen?
Aye.
And Crockett?
Yes.
Bork?
Yes.
Excellent. Those are approved. Now appeal number 2713, practical difficulty variance appeal by Mark Muller Architects. We have a motion to approve those as they were presented and everyone has had a chance to review and any edits, corrections, comments, Mr. Karen?
Just a clarification.
Yes.
Should I also make that motion?
Yes, please.
All right, I motion to approve the written minutes for appeal number 2713. And I don't have any questions or concerns.
The draft written decisions, not minutes.
Sorry.
It's okay. We get what you're saying.
Draft written decisions for appeal number 2713.
No worries. We all know what you're saying. Second. Excellent. All those in favor? Mr. Freilinger?
Aye.
Was there any discussion, any comments?
None.
Yeah, no, I
No.
think it was handled. Sorry, I didn't mean to inadvertently rush that. Mr. Freilinger?
Aye.
Mr. Crockett?
Yes.
Mr. Bork?
Yes.
Mr. Karen?
Aye.
And I'll vote aye as well. So that takes care of our draft written decisions. We'll deal with 2710 and 2712. Is your pen, Brian? Are we writing this in red? I don't think. So now we're going to go to the discussion of our remote. Thank you. Remote meeting policy. So in your packets, you would have had a nice packet put together by Mr. Jay Chase, describing town's policy, state policy, mandates from the state, and given municipalities authority for remote participation that was granted by the governor's executive orders during the pandemic and during the state of emergency. Remote board meetings are now okayed permanently. So should a municipality or town want to go virtual all the time, they certainly can. Obviously, town of Scarborough likes to, and I also like to keep everything in person, but we want to give the ability for anyone who is at home, who can't make it to a meeting in person, to actually share and take part in it. I guess the question here is, and correct me if I'm wrong, Mr. Longstaff, is the town looking for us to provide them our preference with whether we would keep going with the hybrid model of the virtual presentation combined with the live presentation going forward, given normal state rather than the state of emergency?
So, yes, so as I understand it, and believe me, this is confusing. I don't know if anybody else found it confusing. I certainly did.
It's awfully confusing.
And so I will admit that right up front. But as I understand it, and I hope I'm right, you have a couple of options. You can You can do nothing. You could have no policy, in which case it basically goes right back to the way it was pre-COVID. Meetings are here in person. The public can view it, local public can view it on the local television channel, public access, whatever they call it here. And everyone has a right to attend and participate in person. You can also craft a policy that says that board members must be here in person, no exceptions, no remote participation, but you can also allow for public participation to happen remotely if you want. So in other words, we would continue to have the Zoom meeting in order to allow the public to participate, just as we're doing tonight.
Yep.
But the board members would not have, really, this whole thing is about the board members. It's really what it boils down to.
Right.
Because what I learned today from the town's attorney is that, I didn't realize this, the public has always had the right to attend remotely if the town provided that function. They could call in, they could Zoom in. I didn't know that. I didn't realize that. It's always been the question of, can a voting board member participate remotely? That, that was never allowed because you had to be here in person to have a quorum and to cast a vote and so on and so forth. The public's always actually had that right, which I didn't know. So you can do a policy where you say the board will not participate remotely. The board must be here in person. The public can participate remotely if they wish. You can even have a motion or a policy rather that says all applicants must be here in person. No exceptions, including, in addition to the board being here in person, no exceptions, the applicants must be here in person. However, the public can still participate as long as they're not the applicant remotely. So you can really go back to the way things were before. No remote public participation at all because you're not going to provide that for them. You can, or you can adopt this policy. And I just want to say one thing. I know I feel like there's probably a few, maybe more than a few of the board members who, having experienced the virtual meeting, not in favor of ever doing that again, don't want to do it. And that's fine. The policy only says that in the case of an emergency, whether that be an illness, whether that be somebody whose job took them out of town, but they're sitting in a hotel room and could potentially log on and participate and make a quorum when one might not otherwise exist. But normally they're going to be here in person. You're all going to be here in person. That's what this policy, this draft policy says. You're going to be here in person unless it's one of those emergencies. And that would also include should there become some state of emergency where the town hall no longer will allow, where we have to go back to the way we were 6 months ago.
Right.
Okay. So the policy it's there to use if you need it. It's not an excuse to be, to go virtual.
Yep.
And so I just want to bring that up. It could be useful. So if you're thinking now we don't want the policy, just think about a few occasions where a meeting might have to get canceled due to lack of quorum. Because, and I know you, Mr. Chair, have been called out of town on business. I'm sure others have. Leroy possibly could be. Rudy, I think, has had. So it happens. And as we've seen, we're having trouble getting that other alternate to stay. So it might be useful. I just want the board to consider that. It might be useful to have that.
Yep.
There's no question that running a meeting this way with, with all of the technology, it's nerve-wracking for me. This was my first real attempt.
I think you did great.
Well, I don't think I did exactly because the whole YouTube thing, anyway, it's different, but we'll get used to it. We'll get used to it and we'll make it work. But I just want to bring up those options. So the policy really is whatever you folks want to make it. And there was just a few things that I didn't realize, particularly that the public participation has always been an option, which I didn't know.
I guess my thoughts on it would be, I don't mind having the virtual session in progress. I think it's a good way for members of the public to participate who normally can't. You know, a single parent at home who's watching kids that wants to take part in an appeal or any kind of process and voice their opinion should have that. I don't think it's encumbering on us to allow them to have that. You know, I don't think it's a really big problem for the public to have access to the virtual session to join us while we're live or while we're not live. When I say not live, while we're at home. I think the threshold should be, you know, whether or not the entire state or the town is in a state of emergency, like where we are with the COVID-19 issue just a few months ago, and where we may be headed into that this winter, depending on what the heck is going to be going on with that. Granted, we're not in the state of emergency at the moment, so I think my opinion is, while we are not in the state of emergency, mandatory attendance in person for board members, unless there's an extreme circumstance where we don't have quorum and we have to have someone try to dial in remotely. Otherwise, I think if we are in a state of emergency, but the town hall is still open for meetings to be there in person, I think at least the chair or the vice chair, whoever's running the meeting, should be required to be there in person at the town hall, and not necessarily for other board members there to be present. I think somebody, because you can't necessarily I fail to see the benefit, or it would look a little bit weird by having no board members here present, everything virtual, yet having people in the audience. So I think somebody would have to actually be here, and it would have to be the person swinging the gavel, except of course, when we're in a true state of emergency and the entire town is shut down, where you can't have in public personal meetings. Does that make sense? Sorry, I didn't mean to.
Yes, it does make sense. And just a question regarding that.
Yeah.
The chair or the vice chair would have assistance with the tech system.
Well, so here's the catch-22 on that. If the chair is going to be here for it, someone from the town, Brian, would have to be here to do that as well. Or somebody like managing this thing. I mean, yeah, you and I would have to be here for it at a minimum, I would say. I don't know, Doreen, you probably wouldn't necessarily be here, need to be here either. Yeah, and I guess at that point, it would be a personal preference. I guess mandatory though, it would have to be somebody from the town to operate the system. And then I would say the board chair to facilitate the meeting. If it's a hybrid during some kind of a weird emergency situation where people are here and people are elsewhere virtually.
I kind of think, Mr. Chair, that if it were that kind of a situation, there wouldn't be anybody here.
No, probably not.
I think, you know, if it got to, I think the whole emergency thing or the conditions under which a board member would participate remotely were listed in the draft policy as illness, illness or other physical condition or temporary absence.
Yeah.
And then the existence of emergency would be, that would require the full board to meet remotely. If the full board was meeting remotely, the town hall isn't open and there would be nobody here. So that's really not an issue. We basically go back to doing it how we've been doing it up until July.
Yeah, I guess my scenario is a little bit too niche to throw in here. Yeah, no, that's fine. I'm agreeable to this. What do other people think? Mr. Crockett first. Go ahead.
I think it should be mandatory for board members and applicants to be here. If public wants to call in or whatever, then they can. It opens up that opportunity. Like Brian said, they've always had it. We just didn't know they had it. But it's really important to see the applicant stand before you and be able to address you in person, and for them to be able to see us in person as well, and addressing them and know that we're actually looking them in the eye and we're seeing and hearing what they're saying.
Mr. Browninger?
No, I concur. And that was the point I was going to make. It's not just us, but I think the appellants need to be in person as well. And we should make that as part of the policy and clear to the public.
I like that. Mr. Bork?
Okay. It's my understanding from looking at what other municipalities are doing and from what I've seen from the state is that each board and committee has to make up their own policy on how they're going to conduct business. So we don't have to follow what town council is doing. We don't have to.
No,
we do something that's completely different. if we want. Yeah, and I think there's good reason for doing it differently than what town council's doing. For one thing, we have alternates, they don't. Okay. And as long as we can stay staffed, and I know there's always a problem, then it's just a matter of having an alternate available to have a quorum, if somebody can't make it. But I definitely feel that it should be mandatory that we be here, the members be here. It's really up to the town to make sure that we have enough members on the board, including alternates. So that's not a problem if somebody's sick or there's some reason that brings them out of town or whatever the situation.
An
may be.
exception, not the rule.
Yeah, but I think if we don't have a quorum, we shouldn't have a meeting. I really think that's important because we do have the capability of being able to cover things with alternates. And it's really our responsibility to make sure that we have enough members here to have a quorum in order to be able to hear appeals on a timely basis. That's the responsibility of the town to do that. Not us individually, but certainly we have a role. By serving on a board, I really do believe it's our responsibility to be here. So, as far as, the applicants, I definitely feel they have to be here. And that we should also encourage anybody who wants to speak to be here. Doing it virtual, as we saw last meeting, can pose problems. And the fact that we weren't prepared to deal with that, and Brian, I know you weren't here, okay? So it's nothing to do with you, okay? But we really should have stopped the meeting at that point.
Yeah, you're right. And I didn't know that was an option.
Yeah, and nobody knew that.
Yeah.
It was an after the fact thing when, we had, 2 appeals to reconsider. So it's an unfortunate situation. We have to, be prepared to, deal with things. And I think the problem with technology, for all the wonderful things it does, is that we can have glitches and we have to, minimize the potential problems with that. If we're overly reliant on that, I think that, we're just asking for more problems like this in the future. So I would ask you, this question then, Brian, are we obliged to have public access remotely? Or is that something that if we offer it on one board, we have to do it for all boards?
No, it's the board's decision. It's this board's decision, how you want to craft your policy regarding.
That's where I was going. I just want to confirm it. So we could easily say, everybody's going to be here in person, including anybody who wants to speak. Unless there's a declared state of emergency by the state or the town, which would preclude in-person meetings, in which case we go to Zoom, like we were doing before. That's how I feel about it. It should be one or the other, okay, not some kind of a hybrid thing as we've been doing. It's just fraught with potential problems. And the meeting last month was really problematic on many levels.
Yes.
And I think we need to learn from that and grow from that.
Excellent.
Pardon me, Mr. Chair.
Yeah.
I just wanted to share my opinion as well. I agree with other board members about the board's need to be present if we're having a public session in person. In the past, should a member not be able to attend, there's also been alternates and they let the board know and worked around it. Certainly if there's not a quorum, move the meeting. So that speaks to the board. For any of the appellants or representatives of the appellants, I think one or the other does need to be in person as well to represent what's brought before the board. However, I do think that for the public, it's my opinion that it should be left open to those viewing online as well. I understand it's not ideal, but I think it's something that should be worked and improved upon as the board moves forward in the future.
I'm inclined to agree with Rudy on this one. And I share David's reluctance and frustration with what happened last month. That even as we were going through the meeting, it felt like we're gonna have an issue because there's a lot of people who would like to be participating and they can't.
Yeah.
The flip side of that though is having come out of the whatever, 18 months that we were doing, or that remote was the rule, 12 months, whatever. What I've gotten feedback from a number of town residents is actually an ADA issue. There are people who can't physically make these meetings because they can't drive themselves here. It's physically difficult to get into here, but they'd still like to be advocates for their neighbors or talk about zoning issues that pop up. And I am concerned about that from an accessibility perspective. So I'm somewhat inclined to take the risk on some of these technical issues that we might have to deal with in the future, for the virtue of allowing for participation from those who physically find it very challenging to get to town hall.
And I think I agree. I think going ahead into the future, this is going to be more the standard and the norm rather than the exception of fortunately, unfortunately, however you look at it. I'm in support of making it mandatory for board members to be present and applicants to be present. In an event where an applicant has to be brought in virtually, is there a way that we can specify in some kind of legal disclaimer or an alert or warning that, you know, should there be an issue with the televised virtual session of this, you know, I mean, we can't be held accountable kind of thing. Is there any way that we could do that? You know, there's an internet outage or something just shuts them right off, or they're disconnected, or if it's a user error and they don't know how to turn their mic on or turn their camera on. And we will not see the end of that for as long as we live either. And I think that, you know, if we can is there a way that we can just make that apparent to anybody who does want to attend virtual, is like, look, this is the risk that you're having to take. If you're an applicant and you're going to risk your one shot or so, or come before the board, and I know I shouldn't say that, but if you want to take the risk of that, your computer and your internet connection is all savvy to do the virtual route, then you can't be disappointed with the results should your internet connection cut out or you get disconnected and we have to carry on without you. Yeah.
I think what we ran into last month was that we advertised it as being both, and we didn't have that option. I think what we're doing now is we're mandating it for board members and we're mandating it for applicants, and we're leaving the door open for someone to go online. That's not precluding anybody from speaking or anything, because we're not advertising it as a Zoom link.
Yeah.
We're just allowing people to come in if they want to. So that I think would probably address what we just dealt with those two appeals, right, Brian? Where we're not, I think the point was we advertised that it was available and then we didn't allow that option to be.
Well, it's not we didn't
usable.
allow it, it's just we were unable to provide it.
Yeah.
It wasn't like a malicious intent.
No, but we were unable to do it.
It was a
so.
technical
Well,
difficulty.
if we were to do something like this, I understand what Peter was saying about the accessibility issue. If we were to make special accommodations for people who have accessibility issues to go remote, but for everybody else, including anybody that wanted to speak, anybody, not the applicant only, but for those people who have accessibility issues, let them speak remotely and have the opportunity to speak that way. Everybody else, why can't they be here? I just don't get it.
No, I
If it's
agree.
important to them, then they should be there.
I actually like that solution. It's kind of,
Case by case.
yeah, we describe the meeting as an in-person meeting at town hall and council chambers. For those who are, due to whatever issues, are unable to attend, here's a link, but it is an in-person meeting. We don't describe it as anything other than an in-person meeting. Because I'm on, emotionally, I'm with David on this one. I think the meeting should be in person. There's something of value from a civic perspective, from a disclosure perspective, from a transparency perspective, for both us as members and for the public to do this in person. But like I said, I did hear from a number of folks in my extended circle who appreciated the ability to participate in town council meetings or watch the zoning board, because they never were able to do that before because they're
Right.
bedbound. So
Yeah. Or they're at home watching kids because they don't have a babysitter. Yeah. Guess what are you looking for us at this point, Brian?
Well, I guess I'd like to know I guess first of all, somebody needs to make a motion so that we have an actual policy motion. And then clearly tell me what it is you want to do. We'll make sure, that'll be your decision for tonight. We'll craft it up in writing because it's obviously not the draft policy.
We could take a look at it again.
And then I'll come back at the next meeting. And until then, your decision is that this is the most important thing. Board members are mandatory. By the next meeting, we don't know what's going to happen. We may be remote. But that's the only danger. If you mandate that you've got to be here in person and you want to change that policy due to a COVID emergency or something else, you've got to come back here in person to make that motion to change that policy.
Well, I mean, I would.
It's not a big deal, but that's the one thing the attorney told us today.
Yeah.
You can't sort of say, oh, well, we'll just play it loosey-goosey. No, if your motion is mandatory board membership in order to conduct board business, then you got to somehow find a way to come back and make a motion to change that because you can't do it
Right
remotely.
now, if in the event that let's say that next month, if the spread of if the number of COVID cases increases dramatically, would the town give a signal to that, we're closed to all public meetings, we're going virtual at this point? Is that like a flag that's raised by the town? Because we could use that as far as, under normal circumstances, the board and applicants are required to be there in person with the exceptions of.
It's possible, Mr. Chair. I don't know. Again, this is a very confusing
Yeah.
thing. It's really hard for me to give you guys good advice other than what you've read in this memo. But I'd say let's start here. Let's get your desires, your wishes for how you want to conduct a meeting outside of any emergency. Let's get that down. And then we'll deal with the emergency when the emergency happens.
All right. Okay, do it.
I'd like to make a motion that all board members must attend in person as well as applicants, leaving the option open for people with disabilities to sign in and view the meeting. And also, in addition to that, if there is a future declaration of emergency, that we revert back to the emergency protocols in place per the guidelines of the state. And what's in here,
Want to say in the town?
state and town, yeah.
Because that way the town would say that, the town may determine we want to shut all that stuff. That way the town could give us direction on whether we should go remote.
I'd actually say state, county, and town, because it does seem like a lot of these directives have
yeah.
been at the county level.
Okay,
So
state, county, and town.
Okay, just to clarify, are you talking about just the applicants or the general public also? Or is that?
We're just talking about board members and applicants.
Okay, so we're not talking about general public at all?
No, we're not gonna
No.
advertise it
No.
as a virtual meeting anymore.
Yeah,
And-
public will have the opportunity to come, and at that point, there'll be occupancy limits posted at the doors, 5 members of the public only, and you let 5 in, then you close the door and you can't let them in at that point.
Like Portland's doing.
Yeah, pretty much.
And then I don't think this goes in the policy, but I think we're in agreement that we should advertise these meetings as being in-person meetings going forward rather than
Yeah,
hybrid or virtual or anything like that. Yeah.
No hybrids.
Second,
Second.
Mr. Bork, nice crack.
That's old age.
Mr. Freilinger, how do you vote?
Yes.
Mr. Crockett,
Yes.
Mr. Bork,
Yes.
Mr. Karen?
Aye.
Do you have a further comment? Excuse me, forgive me. Did you have your hand raised? I didn't see you.
Mr. Chair, I did not have my hand raised.
Okay. How do you vote?
Aye.
Great. I'll vote aye as well. Is that enough direction for you, Ryan? To start anyways?
I'll review the video.
Thank you. Yeah, Phil loves this already. Other discussions? Thank you all for your time tonight. Is there wait?
Before that,
Go ahead.
I've already sent out to the board, like to do a focused training. I've
Yes.
gotten some responses back. Please, I'd like to try to shore this up and because Phil's schedule fills up quickly as well. like to try to do it in September. And he's given me a couple of dates when he can't be there. If anybody knows of any dates in September where they can't be there, and somebody may have already told me, and I'll go back to my emails, but if you, I know we've been here long enough tonight, if maybe by the end of the week at the latest, everybody could kind of shoot me their thoughts on what they'd like to receive some training on and possible dates that they can't, absolutely couldn't be available. And we'll try to do this as an in-person meeting.
Yep. Were there any dates proposed in the email?
I may have, and I don't have it right with me, but
I guess the easiest thing would be to tell you what dates don't work.
that's right. If you could tell me what dates you can't do it, then I'll float some dates that he's available, and we can do, we could do a doodle poll or whatever and narrow it down to a day and time. It's probably gonna, I know Peter said he could do it daytime, but probably gonna be more convenient for people in the evenings, I'm guessing.
Yeah.
So, and we usually do that. We'll have some pizza and we'll,
I just need a couple weeks notice to line up dates here.
understood. Yeah. And that's why I want to try to maybe late September. That'll give everybody a chance
Bring
to
the
work.
kids, they can learn about civics.
I don't have any conflict. Okay. Thank you.
Any further discussion? Anything that anyone wants to bring up at this point? All right, is there a second?
Second.
All those in favor?
Aye.
Meeting's adjourned.